for pronouncement of judgment, item number 64.
In the light of the discussions made above, this court arrives at the following findings. The claim of the petitioner to be considered for appointment to a grade 4 post in the office of the respondent number 3, in the light of the agreement dated 1/3/2011 is rejected. The state respondent shall take steps to pay the necessary compensation to the petitioner for the land acquired in accordance with law. Such exercise for payment of compensation shall be completed within a period of 90 days from the date of this order. Since the land of the petitioner has already been acquired by the state for public purpose, the petitioner shall not reclaim the land. Read petition accordingly disposed.
Bless you, Lordship. May I please, Your Lordship?
Yes.
My Lord, I'd like to mention item number 47, hearing item number 47. My Lord, if this can be listed again on Monday, that is 18th September.
This is a 2018 matter.
Yes, my Lord. However, my Lord, I have some difficulties today.
On the prayer of the learned counsel for the petitioner, listed after a week.
Oh, bless my Lord.
Maybe please, Your Worship.
Yes.
Maybe please to mention hearing item number 51.
Yes.
Your Lordship, this matter relates to minimum scale of pay. Your Lordship, and we have already filed an SLP. The SLP number is 35341, 35342, 35345, 35348, 35353 of 2023, Your Lordship.
In this case?
Yes, Your Lordship, similar matter, minimum scale of pay.
No. No. The facts may be different. The appeal may be against that judgment, but...
The appeal is against that judgment, but it's relating to minimum scale of pay.
So what? Minimum scale of pay, every case may be on different facts and circumstances. Yes.
Your Lordship, then let the better come up after 3 weeks, Your Lordship.
On the prayer of the learned government advocate, listed after a week. Okay. Yes.
Your Lordship, I also beg to mention item number 59. Your Lordship, for 3 weeks will be granted, Your Lordship.
On the prayer of the learned government advocate, listed after 2 weeks. Yes.
Much obliged.
May I please, Lordship?
Yes.
Can we be allowed to make a mention for item number 48 and 50? Lordship, there are other 18 similar rate petitions pending before this honorable court, passed by the Lokayukta to cancel the, which we are challenging the order, Lordship. So the same order has been challenging this item 48 to 50, Your Lordship.
You are for the petitioner?
Petitioner, Lordship, I'm not for 48 and 50, I'm not the petitioner in this case.
Just may I please, Your Lordship? Your Lordship, in fact, it is 3 items, analogous matter. It was heard on the last occasion, and when this matter was heard, it was also brought to the notice of Your Lordship that there are other matters which are also pending. But then the issue involved in the other cases are different. Only thing is that it is a common order passed by the Nagaland Lokayukta, Your Lordship.
Okay.
And the petitioners, like they are appearing in that other writ petition, Your Lordship. Now, though the issues are different, because just to recollect Your Lordship's memory, the order is in 2 parts. First part relates to a different issue which is under challenge in the other writ petition, and the present matter relates to the second part of the order, which relates to
illegal appointments.
Regularization of pantas, Your Lordship. The first part relates to
waiver,
right of condemnation of court. The issue is that, Your Lordship, like the same order by court. That is the only thing. Otherwise, the issues are different. But if the petitioners they have that reservation, Your Lordship, I leave it to Your Lordship, because the order challenge is the same.
Yes, I think we cannot pass a common order. So many cases are involved. No. No clubbing, but if you want adjournment, yes. No clubbing. And in fact, this is not your case.
Yes, Your Lordship, it's not my case, Lordship.
Uh,
So, Lordship, but today's case outcome may affect on our case, Your Lordship.
Whichever, either this way or that way, whichever hearing first, let us see. But I think, adding up all these cases, I think it may not be proper for this court also. Because I think I have seen that all the facts are different. Facts are different. Though it is by a common order,
Yes, Lordship.
I think the Lokayukta has decided about three issues by the same order.
Two issues.
Two issues.
First is right.
One is write-up and the other is irregular and illegal allotments. So let us, I think, decide the case on its own facts. Okay? So what is you are not the counsel here?
No, not for the 48 and 50, Your Lordship.
Uh,
So I pray that these 3 matters listed today and my 18 other matters be heard together. That's what my prayer is, Lordship.
you may be inviting problem for this court if we club all these cases.
They want the matter to be heard together. I leave it to your
But this court may find it difficult to pass a common judgment because all the facts are different.
Lordship.
Anyhow, when is that other matter fixed?
On 5/9/2023, we were given 3 weeks time to file a reply to the affidavit in deposition.
That same case.
Yours.
Is it, when is it fixed?
After 3 weeks, Lordship. That was last week.
Any date fixed?
No, Your Lordship. We were given 3 weeks time.
Yes, Mr. TB, any date fixed?
I'm not, no, except.
Regarding that matter which we had heard, na? Regarding that matter? I think we had heard one similar matter.
Those matters are listed today. 48, 49 and 50.
Oh.
Heard that day. And their prayer is that the cases which are pending, which they have filed, should be also heard together. That is the case. Otherwise, the matter which was heard the other day, Your Lordship, and then fixed today for further hearing, Your
You were directed to produce the judgment.
Lordship.
Correct.
Those are the matters listed today, but they have furnished their cases that since common order is being challenged, so they want this matter to be heard along with those other matters. That is the thing. I leave it to Your Lordship. Except for the fact that it is a common order, the issues are different. But I leave it to Your Lordship.
When are those matters listed?
Lordship, after 3 weeks, it was listed last on 5/9/2023.
15 or 16.
18 matters.
Then let us see, we will pass order today, but if actually the facts are different, then we may segregate.
Lordship.
I leave it to you.
Yes, Benawabang.
He is here.
Yes, Mr. Benawabang. Somebody, not the lawyer for this case, is mentioning.
Since the order challenging before the Honorable Court is of the same, if the court feels that it could be heard together, for me it's no objection. But if the court feels that it can continue also, I will.
What is the other case?
It's about dismantling of
No. What is the number, case number?
208 of 2021
Not all the cases, just cite one case, 208.
of 2021.
Okay, 48, 49, 50. We will just see, let us see whether we will not invite any complications. Listed along with WPC 208/2021 and the other analogous writ petitions. Okay? For the time being, we pass that order. Let us see. But this court is not very interested to take up all the cases together. Even these three cases, this court was of the view that the matter has to be segregated. That is what this court has expressed. And, let us see. Let us hear all the parties and let's see. Excuse me. Let's go to the another. Let me arrange the fan. It's too hot. Yes.
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention item 46 on behalf of my senior, Mr. Gauhati. He has some personal difficulties, so
This
I
is
beg.
2017.
Yes, Your
I
Lordship.
think it's high time we at least make some effort.
If 2 weeks can be given to us, Your Lordship.
What is wrong with Mr. Yamawati?
He has some,
He is there. You are mentioning on his behalf, he is there. Mr. Yamawati, what is the matter? This court is willing to take up this. Yes.
Not today, Lordship.
Why?
I have a problem with it.
This is 2017 matter.
Therefore, tomorrow, Lordship.
We are listing it day after tomorrow. If not, we'll impose cost. Please be ready. Mr. Yamawati, the learned counsel for the petitioner, seeks adjournment of the case on, what is day after tomorrow? On 14/9/2023. Prayer is allowed. It is made clear that any adjournment shall be subject to cost. Yes.
May it please Your Worship.
Yes.
I beg to mention item number 60 on behalf of my senior. As my senior is on leave, so kindly listed this matter after 3 weeks.
Who is your senior?
Likase Sentum.
Mr. So-and-so makes a mention on behalf of Mr. L. Likase, the learned counsel for the petitioner, and seeks adjournment of the case when?
After 3 weeks.
After 2 weeks. Prayer is allowed, listed after 2 weeks.
Much obliged.
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention here in item number 45. Your Lordship, here I have filed an affidavit withdrawn by power. And according to notice has been sent to the petitioner, however, written notice is still awaited, so another 2 weeks may be given to Your Lordship.
Return notice on the petitioner?
Yes, Your Lordship.
MS V. Terry, the learned counsel for the petitioner, submits that she and her associates has withdrawn from the case, and accordingly notice has been issued to the petitioner. Stop. The notice issued to the petitioner is, however, yet to be returned. Listed after 2 weeks.
Your Lordship, item number 55, Your Lordship. I thought this matter be listed after 2 weeks.
Item number
55.
MS V. Terry, the learned counsel for the petitioner. 6 for adjournment after
2 weeks.
2 weeks. Prayer is allowed, listed accordingly. Okay.
Your Lordship, and item number 56. This item may kindly be fixed on Monday, Your Lordship, that 18.
Item number 56,
Yes, Your Lordship.
on the prayer of the learned counsel for the petitioner, listed on Monday.
Yes, Your Lordship.
What is Monday?
18.
Who is for the other side?
My lord, I'm appearing for.
Okay.
Yes.
Monday, listed on. What is Monday?
18/9.
Okay. Listed on 18/9/2023. Okay.
Deeply obliged.
What's up?
May I please, Your Lordship?
Yes.
I beg to mention item number 40. Since my senior is on indisposed, so can you list the matter on next week?
Item 40. Yes, we will see. Let the list come. Okay? We will see according to the list.
Much clear.
Okay?
This, Your Lordship.
Yes, please.
Lordship, I would like to mention hearing item number 54 on
54.
behalf of my senior, Mohammed.
Okay, what is What is
Lordship,
referring-
my senior has some personal difficulties. Kindly list this
MS.
matter to 2 weeks.
MS so-and-so makes a mention on behalf of Mr. Jamir, the learned counsel for the petitioner, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed after 2 weeks. Okay.
Lordship, I would also like to mention item number 62.
Yes.
Same prayer.
Okay, Mr. Wati,
Yes, sir.
this is a counsel for the respondent,
Respondent
62.
number 4.
Respondent number 4. 62, okay, after 2 weeks. Okay,
Lordship, Lordship.
yes.
Yes, awesome.
May I please, Your Lordship? Lordship, I beg to mention item 11.
11,
Lordship, I just received a copy of the affidavit filed on behalf of respondent number 3 and 4. So allow me to seek instruction, Lordship.
Madam, let it come as per the list. Let us see the last order.
Lordship.
Okay, let us see the last order.
May I please, Lordship?
Yes.
Lordship, I beg to mention hearing item number 58. Lordship, here the pleadings are completed, so let it come up for hearing of the.
It is for hearing, it is already listed for hearing. The question of pleading, completion of pleadings does not arise.
Lordship, I would like to seek 3 more weeks time again.
Your good name,
Mane Kohima, on behalf of Sir Mojan.
Mr. Senso, makes a mention on behalf of Mr. Jamir. Item 58, correct?
Mane.
The learned counsel for the petitioner and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly. Okay.
Lordship, I would like to mention hearing item number 52 also on behalf of my senior counsel for respondent number 3. Lordship, let it come up for, after 1 week.
Mr. Senso makes a mention on behalf of
Sir Mojan.
Mr. Jamir, the learned counsel for the respondent number 3, and seeks adjournment of the case after 2 weeks.
Lordship, there's an interview.
Prayer is allowed, listed accordingly. Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Deeply obliged.
Okay.
May I please, Your Lordship?
Yes.
May I please to mention hearing item number 57 on behalf of AIME. Lordship, let the matter come up after 2 weeks.
Okay.
57.
MS Livika makes a mention on behalf of MS AIME, the learned government advocate, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly.
Lordship.
For motion, item number 1.
Yes.
But Mr. Lordship, this instant matter is arising out of non-regularization of service of the petitioner. The petitioner was appointed as work church carpenter helper.
Mr. Sanso, learned counsel for the petitioner. It is the case of the petitioner that he was appointed as a work charge carpenter helper on 12/9/1985 in the scale of pay under the establishment of the executive engineer, PWD, within bracket H, Kipiri Division, Nagaland. It is further the case of the petitioner that the government has formulated the OM dated 17/3/2015 for regularizing work charge employees, for regularizing work charge and casual employees who are enjoying scale pay and who have completed 30 years or more of continuous service. Stop. However, in spite of the scheme laid down by the government, the petitioner service was not regularized, and he has been released from service after serving the department for 35 years. Stop. Being aggrieved, the petitioner is before this court. Issue notice to the respondents, returnable within 4 weeks. Since Mr. Tiba appears on behalf of the state, since Mr. E. Tibapong, the learned government advocate, appears on behalf of the state respondents, no formal notice need be issued. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned state council within a period of
3 days.
Within a period of 3 days from today, listed accordingly.
Much of
For motion, item number 2.
Yes, what is your case? I have been reading your petition time and again, but I am still not able to understand.
Your Lordship.
What are you aggrieved by? Just give me the gist.
Yes, Your Honor. Actually, I'm aggrieved by the way, since there is a tradition while conducting this VDP election, this village council, they used to adopt regulation. And as per the regulation, this election has to be conducted. So here my grievance is that the village council, which the regulation was adopted, not as per the regulation, this election was conducted.
So whether you are aggrieved by the election of the VDP members only of the Sikh Hill or of the entire village?
Only Sikh Hill, Your Lordship.
Only Sikh Hill.
Only Sikh Hill, Your Lordship.
And why?
Since, Your Lordship, as I said, as per this Sanis Village Council, they had adopted regulation, and I have mentioned in my petition, this election was not conducted as per the regulation adopted by the Sanis Village Council.
Sikh Hill.
Only with regard to Sikh Hill, Your Lordship.
Sikh Hill. So who are the respondents appointed from Sikh Hill?
Actually, Your Lordship, there is, after conduction of this election, this village council, they have on the same date itself, it's a common result. So particularly, there are only 2 respondents.
Yes.
With regard to
Who are the respondents? That is what. Who are the respondents? Respondent 13.
13, yes, Lordship, 13 and
12.
13.
12, 13.
12 and 13, Your Lordship.
You are also aggrieved by the election of the VDP secretary?
Yes, Your Lordship.
Why?
Since Your Lordship, there are total 4 khels, khel A, B, C, and D. So out of these 8 members, one will be selected as VDP secretary. So since there was manipulation in the conduction of the election, so that is how indirectly it is also affected for selection of the VDP secretary.
What is this VDBMC?
Village Development Board Management Committee.
VDBMC.
Village Development Board Management Committee.
Village Development Board
Management Committee.
You correct me if I'm wrong.
Okay.
Heard Mr. So-and-so, the learned counsel for the petitioner. Stop. The present writ petition has been filed, impugning the letter dated 9/6/2023 and 13/7/2023. Written by the Sunny's Village Council to the Additional Deputy Commissioner, Sunny's Nagaland, forwarding the names of the newly elected VDP Secretary and the members of the VDBMC. And the order dated 21/7/2023. issued by the Deputy Commissioner Waka Nagaland, appointing the members of the Village Development Board Management Committee, Sunny's Village, for a period of 3 years. For a period of 3 years, from the date of issue of the order up to 21/7/2026. Stop. The petitioner is aggrieved, more particularly with the appointment of respondent number
12 and 13.
12 and 13. With the appointment of respondent number 12 and 13, who were elected from the CKL of Sunny's Village. Stop. It is the case of the petitioner that the respondent number 12 and 13 were selected/nominated as the member VDBMC. In violation of the resolution adopted by the Sunny's Village on 5/6/2023. The petitioner is also aggrieved by the election of the respondent number 10 as the secretary, VDBMC, on the ground that the secretary was appointed by the members of the VDBMC, including the respondent number 2 and 13, who were appointed in violation of the resolution of Sunny's Village, correct?
Yes.
So, issue notice to the respondents, returnable within 4 weeks. Mr. V. Jamomi, the learned government advocate, appears for the respondent number
1, 4, and 5.
1, 4, and 5. Therefore, no formal notice need be issued to the said respondents. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned state counsel within a period of?
Your Lordship, 3 days.
Within a period of 3 days from today. In so far, why this chief electoral officer Waka?
Your Lordship, since it's VDP election, so his role is also there, Your Lordship.
Who is chief electoral officer Waka?
It is equivalent to DC.
No, you cannot say that. Do you have any office, chief electoral office? Waka? Governor, yes, Mr. MT. And why is this Chief Election Officer, State Election Commission? Why your VDP election should involve all these officers?
Since your lordship, it's a election, whether it is.
See, you consult some of the senior lawyers in Gauhati, the Kohima bench. But there's so many lawyers who are well conversant with writ petitions. You at least have a consultation with them. Your Chief Election Officer, State Election Commission, Nagaland, D Block, Kohima, the Chief Electoral Officer, Okha, Nagaland. Your VDP, this selection nomination should not involve this office.
Your lordship, since whether it is local election, this whatever this sequence of these electoral officers, so I have to implement them.
You should not implement them. Insofar as the respondent number 62 But why are you implementing all these VDP members when you are aggrieved only by 12 and 13?
Since regarding this VDP secretary, your lordship, because there were 4 kills all together, so ultimately we have to also seek their response also regarding VDP, selection of VDP secretary.
I don't know. Insofar as the respondent number 6 to 14 is concerned, the Learned Counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of
3 days, your lordship.
Within a period of 3 days from today. Insofar as the respondent number 2 and 3 are concerned, this court feels that they are not necessary parties and therefore their names are struck off as respondent number 2 and 3 from the writ petition. Listed after 4 weeks.
Obliged, lordship.
For motion, item number 7.
Mr. CT, the same issue here.
Lordship.
So we listed before appropriate bench.
Lordship.
Okay. Listed before any appropriate bench without me. Okay.
Obliged.
Yes.
For admission, item number 4.
Yeah, please, Your Lordship.
Yes.
My Lord, firstly, I tender my sincere apology, my Lord.
Yes, what is
I
that?
have overlooked the costlies and I could not bring the file. So let the matter be taken up on trustee, my Lord.
Because they normally this court, is it for hearing?
Yes, yes.
What is the matter about?
Lordship, it is, the matter relates to appointment on the basis of landowner. On 23rd March this month, 2023, Lordship has passed an order directing the government advocate to file an affidavit showing the basis, on what basis the respondent number 5 was appointed.
Okay.
They have filed an affidavit and they came out very clearly that the appointment of respondent number 5 is on the basis of landowner, and so far as the petitioner is concerned, he has already availed appointment on the basis of landowner. Therefore, the 5th March 2018 policy will not cover the case of the petitioner to consider his case for appointment on the basis of landowner.
Have you availed that benefit?
Yes, Your Lordship, it's already been ever.
So,
No, Mr. City, who is for the petitioner?
Yes, Your Lordship.
And you are for the...
I am for the phone number 5. I stood in the wrong place.
So you have availed the opportunity?
Yes, Your Lordship. Your Lordship, on the earlier occasion, the petitioner has approached this honorable court, praying for challenging the appointment of the respondent number 5, and also praying for appointment on the basis of land ownership.
Correct.
Your Lordship. But during the pendency, the government, by notification 5/3/2018, had framed a policy regarding the appointment of land ownership.
Correct.
Your Lordship. Since for the appointment on the basis of land ownership is already being ever by our clan, Your Lordship, this honorable court was pleased to withdraw the petition with the liberty to file afresh.
Not you were asked to, you had withdrawn with liberty to file.
Yes. Your Lordship.
So this is the second round of litigation.
Yes, Your Lordship.
So the government says you have availed the opportunity?
Yes, Your Lordship.
What more?
Your Lordship, I have filed these petitions to advertise the said post.
To advertise the said post?
Yes, held by the respondent number 5.
Okay.
Lordship, in order to grant that relief, the second writ petition, the government has issued an office memorandum during the pendency of the writ petition on 3rd March 2022, whereby government has came out with a policy that for appointment on grade 4 on the basis of landowners, the requirement of advertisement may be dispensed with.
You are also a landowner?
Yes, we are all landowners. We belong to the same descendants. He has already again. I have not. So I have to keep. Now, for advertising the post, government has already issued an office memorandum.
Yes.
Dispensing with the
Advertisement.
Provided.
In cases where it is difficult.
Difficult number 2, if the appointment of the person concerned has been done with the prior approval of the government. I have been appointed on the basis of the government approval. After obtaining proper government approval.
What is the nature of your appointment?
I have appointed.
What is the nature of your appointment, Mr. City?
Appointment.
What is the nature?
Since I am the landowner, I have applied for the post.
Okay.
And then it was considered, and then government has accorded approval, and I have been appointed. And even in the subsequent writ petition, they have not challenged the approval of the government. Therefore, in absence of any challenge to the basic order, whether a direction can be issued to the petitioner, either to advertise or to quash my appointment, Lordship. That is very simple, Lordship.
You have not challenged the approval of the government?
Yes, Your Lordship.
Anyhow, let's hear it on Monday. Let's hear it on Monday, okay? Coming Monday, okay? On the prayer of the Learned Council for the parties, listed on 18/9/2023, okay?
Much.
For admission, item number 5.
Yes. Item number?
That is a Lordship.
Yes.
Lordship, on the last occasion, Lordship, this honorable court has passed a specific order, Lordship, granting 3 weeks time as a last chance, Lordship.
Last chance?
Lordship. However, Lordship.
This is by my Lord Elias Jamir.
Lordship.
Yes, so what is wrong with you?
Lordship, I have sent a reminder to the respondent, Lordship. But however, till date, Lordship.
What is your case, Mr. Lima?
Lordship, I am challenging the impugn order dated annexure.
What is impugn order?
Giving 15 days notice to respondent number 1, petition number 1 for eviction. Your Honor, the irony of the case is this.
No, just wait. What is this, your impugn order? Impugn order directs you, gives you 15 days to vacate the land.
Yes.
Whether it has been stayed.
Yes, Your Lordship.
Then it's all right. The stay is in your favor.
Lordship.
So why do you rush things?
Lordship.
If the case goes against you, immediately you have to vacate.
Lordship,
So avail the benefit of stay.
Lordship, this matter has been pending for nearly 3 years.
3 years.
And the Honorable Court was pleased to issue last chance to the respondent also. And Your Honor, I have a very good case.
Okay.
Not only for stay, but for dismissing, quashing the order.
I had Mr. V. Jimomi, the learned government. I had Mr. I. Limatushi, the learned counsel for the petitioner, and Mr. V. Jimomi, the learned government advocate for the state respondents. By the order dated 18/8/2023, the learned government advocate
I was granted 3 weeks time, Lordship, to file an affidavit.
was granted 3 weeks' time as the last chance to file counter affidavit. Stop. Today, when the matter is listed, Mr. V. Jimomi submits that he has not received
Lordship.
the instructions, the necessary instructions, and therefore seeks for
In spite
another,
of several reminders, Lordship.
in spite of several reminders, and therefore seeks for another three weeks' time to file the affidavit in opposition on behalf of the state respondents. Prayer is allowed. 3 weeks' time is granted to the state respondents to file affidavit. Stop. It is however made clear that if on the next date no affidavit is filed on behalf of the state respondents, the matter shall be heard without the affidavit of the government, listed after 3 weeks. Okay.
Lordship, interim may be continued.
The interim order passed earlier shall continue till the next returnable date. Okay.
For admission, item number 6.
Yes, Ms. Berry.
May I please, Your Lordship? Your Lordship, I'm here to find and reply to the counter file by the state by the respondents, Your Lordship.
State respondents?
No, there is no state respondents here.
Oh,
My apology.
by the respondents.
Yes, Your Lordship.
Mr. Yamawati, you are for the respondent number, or Union of India, and Mr. Fuseko is for the other respondents.
2.5.
Okay.
2.5.
So to whose affidavit do you want to file reply?
The affidavit filed by the respondents, Your
Okay,
Lordship.
MS V. There, the learned counsel for the petitioner submits that she may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondents. Prayer is allowed, listed after 2 weeks.
Bless you, Lordship.
For admission, item number 7.
May I please, Your Lordship?
Yes, please.
Lordship, kindly grant us 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondent.
MS so the learned counsel for the petitioner seeks for 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 2 weeks.
Not your Lordship.
For admission, item number 8.
Yes.
Your Lordship, pleadings are completed. The matter may be listed for admission hearing.
Okay.
Lordship, here, in terms of the notification number 79, dated 19 June 2023, issued by the Honorable Court. I have sought the leave of the Honorable Court to amend the cost circle of my affidavit in opposition. So I have sent back for signature the deponent, but I have not received. So a short time will be granted. So as to enable me to file the amended copy of the affidavit in opposition.
Okay.
On the court of the cost.
Yes, yes. Mr. Im Tim Sung, the learned additional advocate general, Nagaland, is allowed 2 weeks' time to file the amended affidavit in opposition, listed after 2 weeks.
Your Lordship, there is a status quo order that may be continued.
The status quo order passed by this court? shall continue to remain in force till the next returnable date.
Much obliged.
For admission, item number 9.
Yes,
Principal, I'll be given 3 weeks time to file my affidavit.
affidavit in opposition.
Yes.
Oh, expedite your affidavit. Okay, Mr. Yamawati, CGC.
Okay.
The learned CGC is allowed 3 weeks' time to file affidavit in opposition on behalf of the Union of India. Listed accordingly.
For admission, item number 10.
May I please note?
Yes.
Lordship, the affidavit reply is under preparation.
Okay.
Kindly give me 1 week.
Mr. Mani,
Yes, Madam.
the learned counsel for the petitioner, 6 for a week's time to file the affidavit in reply. Prayer is allowed, listed after 2 weeks.
Give your blessing.
For admission, item number 11.
Yes, ma'am.
Lordship, I just received a copy of the affidavit in opposition filed by, on behalf of respondent 3 and 4, 2 and 3.
Respondent number
3 and 4, Lordship.
3 and 4.
Yes.
Yes, wait, let me see who are the respondents, 3 and 4. Oh, State of Nagaland, Deputy Commissioner.
Lordship.
Well, what about the union, ma'am?
Lordship, they have filed the affidavit.
They have filed.
Yes, and we have filed with reply also to that effect, Lordship.
Okay. And who is representing the union? Mr. Yamawati?
Lordship,
Are you representing?
Mr. Mehdi,
Mr. Mehdi, okay.
he is not present today, Lordship.
Okay, okay. But he has filed his affidavit.
Yes.
He has filed his
Filed his
affidavit.
affidavit, Lordship.
Okay.
So,
Okay.
allow me to seek instruction, Lordship, if I may be allowed to apprise this court a little bit about the fact of the matter, Lordship. This case was previously made analogous with 2 other writ petitions.
Okay.
With WPC 1 of 2022 and WPC 264 of 2021. 1 of 2022 and 264 of 2021. Lordship.
2021.
Yes.
Okay.
We're having a similar prayer, Lordship.
Okay.
The petitioner here is seeking land compensation, Lordship. Now, in those 2 cases which were made analogous, the petitioners have already received relief. Relief was granted by
The petitioners therein.
Yes.
Therein.
Yes. So they have received relief in those 2 analogous matter.
Okay.
So just this year only they received relief. So the matter was closed. But for this case, Lordship, the state respondent have sought time to file a separate affidavit. The difference in this case with those 2 analogous matter was that the petitioner's land was not assessed. But Lordship, I should say that this is a covered case because the same petitioners in those 2 cases and the petitioners are from belonging to the same village. So even in this prior, Lordship, if you look at this, I have enclosed
same area of land.
Same area, Lordship, in the same village. And to that effect, Lordship, I have also in the affidavit replied to the affidavit filed by the Union of India, Lordship. I have enclosed the statement made by the village council of the village, saying that validating the claim of the petitioner that his land has compensation was not received, Lordship. So, in similar matter, Lordship, when in 2 writ petition, what this court has previously done for the same project in the same stretch of land is that since the land construction was already completed and it has been some time, already damage is done. So this court has directed the respondents to conduct a spot verification. And that was done, Lordship. And subsequent writ petition, This honorable court has passed a direction saying that, Lordship, if you would kindly allow me to read page numbers 37 and 38. Just one paragraph. Paragraph 16, however, this court does not have to go further into the aspect for the reason that in terms of the orders passed by this court in writ petition number 142K of 2016, a joint verification was already being undertaken which found that the petitioner's name was affected, which also found that no compensation has been paid to the petitioner. The only hurdle coming on the way of payment of compensation is for the reason reflected in paragraph 3 of the said report dated 30/03/2017, which states that since the assessment is to be made in respect of the damage caused 4 years earlier, it would not be practically feasible to make any realistic assessment now of the damage caused. This court is of the view that the difficulty can be overcome if the state government makes a reasonable assessment on the basis of relevant records available before it, which the authorities consider proper and adequate. When making the reasonable assessment and conclusion, the views of 89 RCC GREF may also be obtained as there is no other method of making assessment. After a lapse of so many years of the construction of the road, the state authorities may fix an amount of compensation by following the similar criteria applied to the other affected landowners of the aforesaid 4 villages as far as possible. Thereafter, union respondents, after necessary verification for payment of compensation has been made in respect of the claim made by the petitioner, shall release such compensation amount to be paid to the petitioner. The aforesaid exercise shall be undertaken by the authorities within a period of 4 months from today.
That is in respect of this analogous.
Lordship. So, Lordship, similar yardstick can also be applied in this case, where joint verification can be undertaken.
Yes.
What is the stand of the government?
Actually, Your Lordship, here, the landowners, the lease of the landowner is submitted by the concerned village council. So without their submission, we cannot do anything. And here, PRT, the respondent number 1 and 2 are involved here. So in other analogous 264, 21, and other analogous, those landowners were the Chinan landowners whose name were recommended by the council village council. So which we have done spot verification, assessment, and bill was made by the respondent number 1 and 2. But here in this case, earlier, another case, the petitioner case was, if I'm not mistaken, was dismissed or returned, something like that.
No,
And present case also, it's not the one. But present case, his name should be recommended by the Council Village Council and submitted to the respondent so as to make necessary verification and
Madam, your name is not recommended as of
Yes.
this.
It's not about that, Lordship. No, what has happened was that the petitioner has been going to the former deputy commissioner's office and requesting, because he was also never given notice when the road construction was undertaken. So he has been requesting the deputy commissioner to do something about it.
But if the government is saying that actually your name has not been recommended by the village council, why don't you approach the village council?
Similarly, Lordship, even in the other writ petitions that was already disposed of, those petitioners' names were also not included. But so this court has directed that a spot verification may be done. So even in this case, Lordship, the village council has, I've also enclosed, as I stated earlier, that in my affidavit reply to the affidavit filed by the union, that there is a letter issued by the village council.
Is this the case where the union was willing to pay you?
Yeah, in fact, the position of the union is that it's willing to pay, but the thing is that assessment was not done because assessment has to be done by the state government, Lordship.
Correct.
So to overcome the difficulty, just a simple step needs to be taken. It's just
Who pays the money? Who pays the compensation? Center. So what is difficulty for you if actually he is late?
The thing is, I cannot go and just make the assessment. I have to do under the direction of village council, who is best known to the landowners.
Since
so unless it is recommended or prescribed or say submitted by the village council, those are the China landowners. The land need to be assessed. So we can do it.
No, madam, what is the difficulty for you to approach the village council, tell the village council to recommend your name to the government as the landowner? The matter should end there because the government is willing to pay you. The Union of India is willing to pay you.
Lordship,
so I think it should not be very difficult for you to approach the village council.
Actually, we were in fact not directed like that before, Lordship.
You take that step. That is even without the direction. You take that step.
Lordship.
You take that step. You have heard the learned additional AG.
If that is the case, then Lordship, kindly give me some time.
We will
Lordship.
also give you time to file your affidavit in reply. In the meantime, you take that step also.
Lordship.
And then I think it will be good if you can take that step. And if you can bring that recommendation to the notice of this court.
Lordship.
Yes.
And also, if that can be recorded, the statement of the minority friend can be recorded, Lordship, in the order, that I can take step accordingly, Lordship. The recommendation has to come from the village council.
It is a court proceeding.
No, see, that is his submission, and this court is also pressing.
No. You just take that step. You just take that step. And then you can make a representation to the deputy commissioner on the basis of that recommendation given by the village council. And you can place that before this court so that this court can also know what is going on.
Lordship.
And we will also pass necessary orders. Okay?
Lordship, in that case.
We will not take judicial notice of what the learned additional AG has said today by reflecting it in the order. But you can take, since you have heard him.
You see, in other disposal of petition file, they have received a compensation. Because of the landowner, the village council, they have given the lease to the respondent.
Normally that.
We have assessed. So it is not a question of a statement or it is not a procedure of the working system.
Sometimes there is some inadvertence overlooking the name of the landowners, madam. So this might be the case. So I think maybe some inadvertent mistake was there, overlooking your name and the name of the petitioners in the connected writ petitions.
Lordship, in that case, if a direction may be, stated in the order so that I can also take necessary steps, Lordship.
Like what directions?
As to make a representation to the village council, then to the deputy commissioner.
It cannot be done by direction of the honorable court.
What is your affidavit in opposition? What is your?
I have explained. That
Let us see.
is not included. Is that the land of the petitioner doesn't fall under there.
See, Mr. Im Tim Sung, I think you should also not be very rigid in your stand that so as to disentitle the petitioner from getting compensation.
I'm highlighting the functioning.
Because when the Union of India, who is supposed to actually sanction the money, they are willing to pay provided the state government, if his land has been acquired in reality. I think state government should also give all.
No, we have no objection. But is it so necessary to direct the court to give the assessment of the petitioner land?
No, we are not directing that. We are not directing that, but I am telling you that since actually like the Union of India is willing to pay the compensation. If his land has been inadvertently omitted from this survey, then I think the state government can actually extend all help.
We are ready. It is a deed of the petitioner. Whether his name was omitted or his land doesn't fall under the order of the law.
No, since actually now the matter is pending before the court. And since you also have notice of this case, I think you can also just go and assess whether actually like what has been stated in the writ petition.
Exactly, Lordship. Exactly, because as per the law, Lordship,
you are trying to make it very, very difficult as though survey is something very difficult job.
Procedure, highlighting the functioning of those.
No, procedure now since you have a judicial notice, you are having notice of this case. So accordingly, you can just go and verify whether actually the claim made by the petitioner landowner is true or not. That's
Yes,
all.
Lordship.
Nothing
It's
very
a simple step. In fact, that is what
you file your affidavit in reply. I think next time let me go through all this and pass necessary orders. Okay. MS Nito Koza, the learned counsel for the petitioner, 2 weeks time
Lordship.
to file affidavit in reply to the
Affidavit in opposition filed On behalf of respondent 2, 3 and 4.
to the affidavit in opposition filed on behalf of the respondent, number 2 and 3.
3 and 4,
Number
Lordship.
3 and 4. Prayer is allowed, listed after 2 weeks. Let's see, after
Lordship.
you file your affidavit, let this court be in session of all these facts, then we can pass some orders.
Yes, Your Lordship.
Okay?
Lordship.
Okay, okay.
For admission, item number 12.
May I please, Your Lordship?
Yes.
The main counsel has some personal difficulties, so I believe this matter may be listed.
Who is the main counsel?
Mr. Pakin Chabo.
Oh, the long name. Pakin Richab. Pakin Richab. Okay. What is the case about? State Bank?
It's about insurance claim.
Oh. Yes, so what is the prayer?
I believe this matter may be listed after 2 weeks.
2 weeks. Mr. Senso makes a mention on behalf of Mr. Pakin Richabo, the learned counsel for the petitioner, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed after 2 weeks. Okay.
Obliged.
For admission, item number 13.
Yes, ma'am. What is it?
Lordship, we have just received the affidavit filed by the state this morning, so we may be allowed 3 weeks time to file a report.
MS Senso, the learned counsel for the petitioner, submits that she has received the affidavit in opposition filed by the state only this morning,
Yes, Your Lordship.
and therefore seeks for 3 weeks' time to file affidavit in reply. Stop. Prayer is allowed, listed after 3 weeks.
Lordship, some of the petitioners wish to withdraw their names from the petition, so I may be allowed to file an NA.
You file, then we will consider.
Your Lordship.
No need any direction from this court.
Lordship.
Okay, you file. Okay. Is there any interim order?
No, Lordship.
Okay, okay.
For admission, item number 14.
Yes, Your Lordship. Lordship,
Yes.
kindly grant me a further time of 2 weeks, Your Lordship, to file my affidavit.
Who is for the petitioner? Who is for the petitioner? None appears for the petitioner. MS Mary, the learned state counsel, learned senior government advocate, is allowed 4 weeks' time to file the affidavit in opposition on behalf of the state respondents. Listed after 4 weeks.
For admission, item number 15.
Yes,
ma'am.
Lordship, I'm granted 2 weeks time to file my reply.
To the government's affidavit? To the government's affidavit?
Yes, Lordship.
MS so-and-so, the learned counsel for the petitioner, is allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Listed after 2 weeks.
Obliged.
For admission, item numbers 16 and 17.
Yes, ma'am.
Your Lordship, I'm here to file my affidavit in reply in item number 16. Your affidavit filed for the state respondents.
16?
Yes, Your Lordship. I've already filed in item number 17.
Okay. MS V. Tere, the learned counsel for the petitioner, submits that she is yet to file the affidavit in reply in the writ petition in WPC 136/2022, and therefore seeks for 2 weeks' time. Prayer is allowed, listed after 2 weeks.
Degree of Lordship.
Would you like to take a break now?
How many minutes? Still we have lots. Okay, we will take a break. Excuse me for 5 minutes.
For admission, item number 18.
May I please, Your Lordship? Your Lordship, this matter was initially being handled by Ms. Sipong Chang. But due to her health conditions, it has been recently transferred to me. I'm yet to receive any instructions.
Mr. So-and-so, the learned government advocate seeks for 2 weeks' time to receive instructions and to file affidavit in opposition. Prayer is allowed, listed up to 2 weeks. Okay.
For admission, item number 19.
May it please your
Yes,
Lordship.
please.
The counsel for the petitioner is on leave.
Who is the counsel?
L. Likase Singtom. So kindly grant 3 weeks time to file affidavit in reply.
The learned counsel for the petitioner seeks for 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed up to 2 weeks.
For admission, item number 20.
Lordship,
Yes.
we may be granted 2 weeks time to file our affidavit in reply.
Okay. Your good name?
Vicky Henyo.
Okay. The learned counsel for the petitioner seeks for 2 weeks' time to file the affidavit in reply. Prayer is allowed, listed after 2 weeks.
For admission, item number 21 and 22.
May it please your Lordship? Your Lordship, here I need to receive instruction. Though your Lordship, another 3 weeks will be granted.
Okay. MS Livika, the learned government advocate, is granted 3 weeks' time to file affidavit in opposition on behalf of the state respondents, listed accordingly.
For admission, item number 22.
May I please, my lord?
Yes, please.
Your lordship, in this matter, I am yet to receive instruction from the department. If 3 weeks' time can kindly be granted to me, my lord.
Yes, Mr. Subon. Okay.
Objection, your lordship.
Mr. N. Angami, the learned senior government advocate, seeks for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
Deeply obliged.
Yes.
For admission, item number 24.
Your lordship, I have a similar prayer in this matter as well, your lordship.
Okay. Okay?
I have no
Okay, see. Okay.
I'm deeply obliged.
For admission, item number 25.
Yes. What
May it please your Lordship? Your Lordship, on behalf of Mind your Lordship.
Okay.
3 weeks will be granted for filing counter.
Okay. The learned counsel for the state is granted 3 weeks' time to file affidavit in opposition, listed accordingly.
For admission, item number 26.
Yes, your lordship. Your lordship, I am representing the state council here, all the state quarters.
Okay.
This matter relates to grant of scale of pay to a contingency employee. Grant of scale of pay
Okay.
to a contingency casual employee.
Okay.
So, lordship, I need allowed 3 weeks time because similar case has been filed specially petition.
Don't mention those cases. Those cases may be on different set of facts. This may be on different set of facts. Just because actually in one case appeal has been preferred doesn't mean that the other case should be listed after that. No. Let us actually look into the case on the facts of the case. Okay. Have you filed your affidavit?
No.
The state, Mr. Moinchin, the learned senior government advocate, is granted 3 weeks' time to file affidavit in opposition, listed accordingly. Okay.
For admission, item numbers 27 and 28.
Please, Lordship. Lordship, pleadings are completed in both the matters.
Okay.
And are listed for hearing in the usual course.
Lordship, I'm for number 5.
Okay. And ma'am, you?
I'm appealing on behalf of my senior, Mr. Gauhati, for Union of India.
Okay. What is the matter about?
Lordship, the petitioners are seeking to absorb in their service in CIH Matsipima. They are serving as assistant horticulture specialist and horticulture specialist.
So what is the rule for absorption?
Lordship, we are relying on the one representation by the ministry to the director of the CIH Matsipima. In that letter, they have said that our service will be adjusted.
Adjusted? Yeah. Does it mean absorption? Mr. Fuseko, what is your case? You're for the?
I'm the UPSC, Lordship.
UPSC. So what is your stand?
Lordship, we're conducting agency only. Conducting the exams.
Okay. What is the stand of the union? What is your stand? We are seeking for absorption. So what is your stand?
In fact,
you are agreeable? Or you have objection to that?
we have objection. We have
Okay.
no affidavit.
Okay, okay. It is submitted by the Learned Council for the parties that pleadings are completed, and therefore the matter can be taken up for hearing, listed for hearing in the usual course.
Next, Lordship.
Yes.
Lordship, if my presence will be recorded, Lordship.
Okay. The name of Mr. Fuseko, Learned Council for the
Number 5.
respondent
UPSC.
number 5, shall be reflected in the daily course list.
No, Lordship, it's reflected, but to be recorded in the order.
Oh, okay, you cancel that last line. Mr. Fuseko appears for the respondent number 5.
Lordship.
Okay. Okay. Okay.
Obliged, Lordship.
Yes.
For admission, item numbers 29 and 30.
Your Lordship, may I please, Your Lordship?
Yes.
I'm praying on behalf of AIMA, Your Lordship.
Yes.
In item 29, she has already filed.
Okay.
But in item 30, she's yet to file. So kindly grant 3 weeks
Okay.
time.
The learned government advocate is allowed 3 weeks' time to file affidavit in opposition in WPC number 40/2023, listed after 3 weeks.
Much obliged, Your Lordship.
For admission, item number 31.
Your Lordship, similar prayer on behalf of AIMA, Your Lordship. She's yet to file in item 31. So kindly grant 3 weeks time.
In item, this is 31.
31, Your Lordship.
Okay, same order. Okay, 3 weeks' time. Okay.
For admission, item number 32.
Next, Lordship.
Yes.
Clearings are completed. So,
What happened to this Lotha Baptist Church?
Lordship,
I think the matter was settled.
No, Lordship, in the last read filed by the CA, Lordship, the court, the Honorable Court directed the parties to settle before the civil court.
Okay.
We are here before the Honorable Court against an order passed by the ADC.
Oh.
Lordship, pleadings are completed, Lordship. So, if the Lordship can list for hearing, Lordship.
Okay. I just submitted by the Learned Council for the parties that pleadings are completed, and therefore the matter can be listed for hearing. Listed for hearing in the usual course. Okay.
Lordship, but the interim, can you continue?
The interim order passed earlier shall continue till the next returnable date. Okay.
Vice Mayor.
Yes.
For admission, item number 33.
Yeah, please, Your Lordship.
Yes.
Your Lordship, on behalf of AIMA, I'm informed that affidavit is in under preparation, so 2 weeks, Your Lordship.
May I please, Your Lordship?
Yes, please.
Your Lordship, on last occasion, that is on 21st of August 2023, Your Lordship. This Honorable Court has directed that no further has clearly stated that no adjournments will be given, Your Lordship.
Yes, the petitioner is on the verge of retirement.
Your Lordship, I'm praying on behalf of AIME.
Tell IME to pay cost.
Your Lordship is under preparation, 2 weeks, Your Lordship. Your Lordship.
No, if it is under preparation, no 2 weeks. When is the petitioner retiring?
Your Lordship, he'll be retiring on 24th of July next year, 2024.
So let us expedite.
Yes, Your Lordship.
By next time,
Yes, Your Lordship.
since the instructions have been received, if no affidavit is filed, we will impose cost on the government advocate.
Your Lordship.
Ms. Livika makes a mention on behalf of MSAIME, the learned government advocate, and submits that instructions have been received and the affidavit is under preparation, and therefore 6 for 2 weeks' time. Stop. Prayer for adjournment is allowed on the condition that if no affidavit is filed on the next date, cost shall be imposed on the concerned government advocate, listed after 2 weeks. Okay.
Lordship.
For admission, item numbers 34 to 38.
Yes, Mr. Kechu.
My Lord, I have received affidavit in opposition filed by the respondents.
Okay.
I may be allowed a week's time to file reply.
Okay. Will it be sufficient week's
My
time?
Lord, yes, my Lord.
Okay. Mr. Taka Kichu, the learned government advocate, the learned counsel for the petitioner, submits that he may be allowed a week's time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after a week.
My Lord.
Okay?
Yes, my Lord.
For admission, item number 39.
Yes.
Please, Your Lordship. Your Lordship, I'm yet to receive instruction. So, another 3 weeks, Your Lordship.
Okay. MS Livika, the learned government advocate, 6 for further 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks. Okay.
For admission, item number 40.
Please,
Please, my Lord. My Lord, this is to do with the reinstatement of the petitioner as medical attendant, Lordship.
The reinstatement.
Lordship. There is while Vigilance Commission, by the report submitted, the complaint report submitted by the government, Lordship. Basing on the report, vigilance report, they were terminated. Some reports, landowner, and some non-essential posts. And when my Lord was senior additional IT Lordship, my Lord has taken up this issue. So,
Department of Health and Human. This is to do with OKA?
my Lord,
OKA.
my Lord, my Lord.
Okay, okay. Yes. Then why did you not bring it to the notice of this court before? This court has already passed 2 orders.
This on the last occasion I was not able to.
Well, this is not to do with OKA. These are not the petitioners.
This is Zinepoto Lordship.
Ah, Zinepoto.
On land ownership list.
No, it's all right, it's all right. It's all right.
So,
What is your prayer?
my Lord, since I'm here to receive instruction,
None appears for the petitioner. The government is allowed 4 weeks' time to file affidavit in opposition. Listed up to 4 weeks. Okay.
For admission, item number 41.
Yes. Yes, Lordship. If my lord may kindly come to the order passed on 11/8/2023. 11/8/2023. May I read on, my lord? Mr. Indim Song, learned additional advocate general, is given 2 weeks' time to receive instruction and to file affidavit on behalf of the state respondents. Since the prayer and the writ petition, as submitted by Mr. Ayo, learned counsel for the petitioner, is only for the disposal of the representation dated 13/10/2022, which is annexed in C to the writ petition. It is made clear that the writ petition will be considered for disposal on the next date fixed, irrespective of whether the affidavit in opposition is filed. Yes, Mr. Imti.
Worship here, just recently I have received one documents from the home, but it doesn't say anything. So I've given the instruction to give more instruction from the department. Otherwise, I have received from some documents from the relating to the petition. I've received some documents, but I feel that
What is difficulty for the government to dispose the representation? Just dispose the representation, either dispose that way, finish the matter ends there. Why actually keep this matter pending like this? Let us see your prayer in the petition. My lord, page number 9. Yes. Page number 9. Prayer number 1. Direct the respondent number 1 and 2 to dispose of the representation submitted by the petitioner dated 13/10/2022, marked as Annexure C, and another representation dated same, marked as Annexure D. And 2. Direct the respondent number 1 and 2 to order an independent inquiry on the fabrication of facts regarding the life threat and premature closure to the life threat call to the 10th Deputy Commissioner, Nogla. What is this life threat? My lord, here, the petitioner was the 10th Deputy Commissioner of Nogla. He received a threat call and he has made a complaint to the competent authority. But without his knowledge, the FIR was closed, the complaint was closed. Who has closed the complaint? Who has closed the complaint? Who has closed the complaint? My lord, there, the officer in charge and the SP of that district, they have closed the complaint without any information being given to the complainant. And here, the present petitioner also filed one transfer petition. A criminal case was pending before him and before the district and session judge Pinsa. A transfer petition was filed. And in that transfer petition, when the state respondent, through the superintendent of police, filed the affidavit in opposition, they have passed negative comments on the professional integrity of the Deputy Commissioner, rather than placing the correct factual positions. And that is how these two representations was submitted to the Commissioner Nagaland and to the Chief Secretary Nagaland, making queries as to whether there was proper inquiry and whether all these statements made before the court are within the knowledge of the Commissioner and the Chief Secretary. So the prayer of the petitioner is just to dispose the two representations which are pending before the authority. That is the respondent number 1 and 2. You have also sought for an independent inquiry? My lord, to that, if I may be allowed to submit. If my representation, two representations are disposed, and after that, I can again come to the court asking for that prayer also. So in present, if these two representations are disposed,
evicted to be disposed of within a specific time, my prayer will suffice.
Yes, Mr. MT.
Your Worship, since I have already given a verbal instruction to supply more documents in order to meet
The verbal things will not do.
we read it.
And you know it.
No, it is occasion only. Verbal is occasion. When they fail to comply with our written correspondence, I used to call. So I have told them I'm not satisfied with this. So a short time will be given because knowingly I have been praying for time to time again. But with the direction, I may be allowed to give a reply.
Because actually, the petitioner is not actually pressing on the prayer number 2.
Yes, exactly.
He is actually pressing on prayer number 1.
Yes.
That is to dispose the representation.
Yes.
What the difficulty is there for you, for the government to dispose of that representation? Either this way or that way finish. The matter is there.
I'm also in between.
You are not in between. You are on the government side.
But still then, unless they furnish all the necessary information, how can I highlight the report?
No, but these things cannot go on forever because the court has already passed a direction.
Yes. What's the direction? With the direction, a time will be given. One opportunity.
I had Mr. Takakicho, the learned counsel for the petitioner, and Mr. Im Tim Sung, the learned additional advocate general for the state respondents. By the order dated 11/8/2023. This court has observed that as the prayer made in the writ petition is only for the disposal of the representation dated 13/10/2022, which is Annexure C and D to the writ petition. It was made clear that the writ petition will be considered for disposal on the next date fixed, irrespective of whether the affidavit in opposition is filed or not. Today, when the matter is listed, Mr. Im Tim Sung submits that he has received certain instructions, which, however, is not clear to him, and therefore he has sought for further instructions on the instructions already received by him, and therefore seeks for a week's time. For a week's time. Okay? For a week's time to get the necessary clarification from the government and to file affidavit and to file the necessary affidavit. Prayer is allowed. 1 week's time. Okay? Will it be sufficient? Will it be sufficient? 1 week's time.
Yes.
1 week's time is accordingly granted to the learned additional AG to file the affidavit. It is made abundantly clear that on the next date, the prayer of the petitioner for a direction to the state respondents to dispose the representations shall be disposed with or without the affidavit filed by the government. Please take care. Next day, we are just passing the order. Okay? Listed after a week. Okay? Okay. Yes.
For orders, item number 450.
Yes. Yes, Mr. MT.
In connection with the order direction dated 16 February 2023.
16 February by this court?
Yes.
Right, just with
For
16.
16 to 2023. That is for urgent verification of the damage.
16 to
23. So, Your Worship, here I have taken sufficient time, but the respondent, Deputy Commissioner, they have conducted a survey of the land of the damage. Then they have that report has received only last week. So the copy is with me, but
You file affidavit?
yeah, I have to file an affidavit.
What is the report?
It is
What is the report dated? Let me see. What is your case?
Worship, I'm trying to restore the private part of my private plot, which is cut off during the construction of Kohima foreland, and for the proper assessment of the damages properties which was made during the construction, road construction.
This is in regard to Kohima Dimapur Road. Which stretch?
yes.
Yes, Lordship.
Kohima, this national highway?
Yes, Kohima.
It is related to a foreland.
Okay. Which stretch?
Worship is near Sechuzubza.
At Sechu.
Yes.
So this joint verification report is in connection with that Sechu land.
Yes, yes.
Okay. Mr. Im Tim Song, the Learned Additional Advocate General. By referring to the letter dated 28/8/2023. Written by the Revenue Officer, Kohima, Nagaland, in regard to the rectified joint verification report of District Land Record and Survey Officer, Kohima, for the land at Sechu Zubza. Submits that he may be allowed to file an affidavit, a detailed affidavit, on the letter dated 28/8/2023, projecting the relevant facts of the case. Stop. 3 weeks' time is accordingly granted to the Learned Additional Advocate General to file the necessary affidavit. Okay. Yes.
Your Lordship, I'm representing the respondent number 1, 2, and 3, so my presence may be reflected.
MS V. Tere. The Learned Counsel appears on behalf of respondent number 1, 2, and 3. Okay.
For orders, item number 43.
May I please, Your Lordship?
Yes.
Your Lordship, in the last interim, Your Lordship, the petitioner was allowed to take steps upon respondent number 3, Your Lordship, through Dusty, Your Lordship. Lordship, we have stripped a copy of the Dusty, however, since the respondents from TC Mon, Your Lordship, were yet to receive the form, Your Lordship, of the Dusty.
Okay. So
even 2 weeks time, Your Lordship.
You were also directed to file affidavit?
Your Lordship, to take effect, Your Lordship.
Mr. M. Solo, the Learned Counsel for the petitioner, submits that he may be allowed 2 weeks' time to file the affidavit stating the dusty service, stating service of dusty service upon the respondent number
3.
3. Prayer is allowed, listed after 3 weeks.
For orders, item number 44.
Yes, what is this?
Lordship, there the respondents are yet to file affidavit in the position.
Yes, Your Lordship.
Yes.
Your Lordship, I'm mentioning on behalf of the council for the respondent number 3 to 6, Mrs. Apila Singam.
Okay.
So, Your Lordship, it's my prayer that this matter will be listed after 2 weeks.
Okay.
On behalf of the state, Your Lordship, Moa Imchen is appearing. He's yet to file counter, so kindly grant 3 weeks time.
Okay. Okay. The learned government advocate, as well as the learned government advocate, 6 for 3 weeks time to file affidavit in opposition. MSV Tere also makes a mention on behalf of MS Apila Santam, the learned counsel for the respondent number 3, 4, and 5, 3, 4, 5, and 6, and 6 for 3 weeks time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
For hearing, item number 52.
What is this, 52? Item 52?
53.
Oh, item 53? 53, okay. What is item 53? Yes, what is this about?
Well, the petitioner, he is a constable in NAP. He served for 14 years, 11 months, in 3 days. After that, he took due discharge from the commandant. However, he was not given pension. But it's the whole issue, Mother.
Yes, Mr. Ansham, kindly highlight.
I'm for the AG not here. Unless the state responded, unless the pension from the ad lordship, we have nothing to say as such.
MS Inauli, are you not willing to pay pension?
No, Your Lordship, here we're saying that since he took discharge on his own will, Your Lordship, he's not entitled for pension. And CCS pension rule 226, Your Lordship, in my affidavit also stated. Para 5, Your Lordship.
What is that? Tell me, give me the gist first.
I'd like to read from the CCS pension rule, Your Lordship. In CCS pension rule, rule 26, forfeiture of service or resignation. Resignation from a service or post, unless it is allowed to be withdrawn in the public interest by the appointing authority, entails forfeiture of past service. So we're saying that since he had withdrawn, Your Lordship, I'm sorry, discharged from service on his own will, Your Lordship, in the sense that he has resigned. So he's not entitled for pension, Your Lordship.
Let us see your discharge letter. Let us see how you have submitted for your discharge. Let us see that application.
42. Right copy is 42A. This is not resignation. We are taking it as a resignation.
Okay, then explain what is discharge and what is resignation with law.
Discharge is with due permission from the authority. Resignation can be any time a person can resign.
What is the law in support of that submission? What is the law in support of that submission?
Rule 5.
No, not rule 5. Give me some law. Resignation and discharge. Give me some law.
Resignation can be it without any permission. Discharge, I have to take due permission. That is the whole difference. So resignation will not come into play.
Where is that law? I accept your submission, but where is that law? You support your submission with law. I accept your submission, but what is the law? The Supreme Court has actually explained what is resignation, what is discharge.
Malot, give me an indication how to look up.
I have also forgotten that, but I have come across that. So the Honorable Supreme Court is in a case actually explained the definition of resignation, discharge, what is voluntary.
Yes, I've given in my page 8 of my writ petition.
No, that is your evidence. That is your evidence. What is the law? You come with law. You come with law. I think we can decide your case only on that issue.
I may be allowed to refer to my para 6.
No, that is your evidence.
Yes.
Is it a law?
Yes.
Is it a law?
Yes.
Let us see.
Rule 5.
Para
6, page 8. CC's Pension Rules 1972 provides Chapter 2 general conditions of what? Rule 5 is regulation of claims to...
We are reading para?
Para 6.
Para 6.
Of my writ petition.
Yes.
Rule 5 is regulation of claims to pension or family pension. One is any claim to pension or family pension shall be regulated by the provision of these rules. Enforced at the time when the government servant retires, one is retired or is discharged.
Yes, so it says it shall be regulated. It does not say that you will be entitled. Yes. It says regulated.
Malo, in that case.
So how is the regulation done in the case of discharge?
It will come under Rule 49, Malo.
What were you reading, MS Inaholi?
Rule 26, Your Lordship.
What does Rule 26 says?
Forfeiture of service or resignation.
Yes, resignation, clearly.
Forfeiture of service or resignation?
Resignation entails forfeiture of service as servants, Your Lordship.
Mr. MT.
Yes.
I'm just giving a day or two. You come with that law. There's a citation, very clear citation of the Honorable Supreme Court, which defines what is discharge, what is resignation, voluntary resignation, and all this. And you come with that. Okay. I think there's a law. I think your case can be settled on the basis of that. Only that issue. Because here you are referring to Rule 5.
Yes.
The word regulated is used, regulated.
This will come under Rule 49.
Rule 49, what is Rule 49 says?
49, my page 11.
Your page 11. Rule 49. Rule 49(2).
Yes.
The amount of pension arrived at on the will be related.
Maximum is qualifying 33.
Qualifying years is 10 years.
Yes, that is what I am saying.
But okay, this will have to be read in the light of your submission on discharge and resignation.
Malo.
So as per Rule 26, resignation entails forfeiture of service.
Malo.
So I want to know whether resignation is discharge. Simple as that. If resignation is discharged, you are entitled to pension. If resignation is not discharged,
just for the argument, Rule 49 is clear that somebody who have not completed 10 years will be entitled only for...
No, that this court has understood.
Yes.
That Rule 49 speaks about the qualifying years.
Yes.
Correct?
Yes.
But now here is a question. You are actually coming before this court.
Malo.
Seeking pension.
Malo.
After discharging yourself from service.
Malo.
Okay.
Malo.
Now Rule 26, which is referred to by the government, says that actually resignation entails forfeiture of service. So I want to know, I want to let you clearly satisfy this court whether resignation and discharge are same. That will settle your case. Okay? So I give you 2 weeks time, 2 days time. Come with that. You have so much of citations. You come with that.
No.
Okay, Mr. Muzir, you are just sitting quietly. I thought you will assess the court on that. You are making a submission saying that unless the government process the pension, you will not be in a position. But here the question of pension. The question of pension depends on, like the submission made by the petitioner, and you are a seasoned lawyer. This court wants you to assess the court. This court is actually like wants the petitioner to clarify as to whether discharge is resignation. So I think that has nothing to do with actually whether the government favoring the pension or not.
In fact, if I have to argue,
Yeah.
then my submission will go
Against the state. It's all right. I think that is, this court may or may not accept what you are submitting, but this court wants you to assist. You are a seasoned lawyer, and this court accepts that. So assist the court so that we can do justice, not for anyone's favor, but for justice. Okay. So you have understood the mind of the court. So come prepared on that. Assist the court. Okay. Okay. He is in your favor. He is in your favor today. We'll listen on Monday. Okay. Tuesday. Yes, Tuesday. Okay. Listen again. 19, 9, 20, 23. Madam, please come prepared on that line to assist the court. Okay. I want you to satisfy this court that resignation is discharge. And I want you to satisfy the court that resignation is not discharge. And what middle part Mr. Muzu will take, let's see.
Much, much.
Okay.
For hearing, item number 61.
Yes, what is this matter?
Lordship, is short subject matter.
What is that short subject matter?
Lordship, when it pertains to determination of industry seniority between the petitioner and the private respondent. There is no service role
There is no service rule.
Frame under Article
309. Who entered service first?
The petitioner.
The petitioner.
That is the general principle of law.
Who entered?
In the promoted post, the respondent authorities choose an arbitrary date, and respondent number 7, who is senior and the entry point, has been shown senior in the seniority list, and based on that impugned seniority list, he was promoted to the higher post of assistant commandant.
Private respondents are there. Private respondents. You are for the private respondent? Okay. Just give me the gist. What is the date of entry in your service?
The petitioner entered the service on 25/7/2000 as Chamata.
2000.
2000.
Regularization.
That is direct appointment, Worship.
Direct appointment. Okay, okay.
Private respondent was appointed in the year 2001.
Okay.
As Chamata. Subsequently promoted to Subedar. And thereafter, Subedar to Subedar Major by command order dated 24/10/2016. The petitioner and the private respondent were promoted to the post of Subedar Major. Now the dispute is seniority in the post of Subedar Major.
That is the next higher post.
Yes.
You entered service in which post?
As Chamata.
As okay, let me just see.
On 25/7.
No, as Zamadar. This is in which institution?
Village Guard Organization.
Oh, Village Guard.
Yes.
Village Guard from
the boss of Jamada Worship, your government employees.
Yes, that is what. So you entered in the post of Zamadar.
Yes.
What is the next promotional post?
Next promotional post is to the post of Subedar.
Subedar. Subedar. And the next promotional post is Subedar Major.
Subedar Major, and thereafter assistant commandant.
Subedar Major. Okay. Thereafter, assistant commandant. Okay. So the seniority dispute starts from Subedar Major.
Yes, Worship.
What was the reason for preferring him?
Lordship, the stand taken by the state responding is that respondent number 7 submitted his training report earlier than the petitioner. So that is the basis how the seniority has been determined and the induced seniority list was issued.
Joining the post of Subedar?
Subedar Major, promoted post. Lordship, on 24/10/2016, both the petitioner and the private respondent were promoted to the post of Subedar Major on 24/10/2016. Respondent number 7 submitted his joining report to the promoted post on 25/10/2016. The petitioner received.
What does the order say? What does the promotional order says?
Promotional order is nothing.
With effect from?
No. The promotion order says, Lordship, page 29.
What is that?
In process of the recommendation of the Development Promotion Committee, that is so and the government approval by so that at 2010-2016, the following Subedars are hereby temporarily promoted to the post of Subedar Major and the be banned of Province so and all other allowances as are admissible to such category of employees under rules in force for VG organization and the government from the date of their training to post. That is with regard to promotion also, not recommendation of seniority. The petitioner received that promotion orders on 26/10/2016, who was posted in Mod in the year 2016 also. Therefore, on receipt of the promotion order, he immediately submitted his training report on 26/10. However, it appears that the respondent number 7 submitted his training report on 25/10, 1 day ahead of the petitioner. So the respondent authorities taken that data training in the boards
for determination of industry seniority between the petitioner and the respondent. Now, what happened, Lordship? After the promotion of the petition and the respondent, the boss of Subida measure, a tentative seniority list was published. In that tentative seniority list, the petitioner is shown senior to the respondent. That is in terms of the data entry into the service, because they were promoted by command. However, by filing the affidavit and motion by the state respondent, as well as by the respondent, that includes the joining report submitted by the petitioner, as well as the respondent. And a representation was submitted by the respondent to rectify the seniority list, the previous seniority list which was issued in 2016. The petitioner was not aware about all this submission of representations by the respondent against the seniority list. And what happened, Lordship? Another tentative seniority list was published. No objection was invited. The petitioner was not aware, apart from the first tentative seniority list. And that tentative seniority list, which was subsequently rectified, showing the respondent number 7 senior to the present petitioner, was kept undisclosed. Here, the respondent number 7 was given promotion in the year 2021. I submitted an RDR application. Only through the RDR application I came to know about the tentative seniority list, which was issued in the year 2018, which was kept undisclosed all along. And that ambient tentative seniority list was the basis for promotion of respondent 7 to the boards of SSL commented. So that is the first point. The second point is, Lordship.
What is the law? On the first point, what is the law?
The law is very the Lordship. For the recommendation of seniority, industry seniority among the employees holding the same post in the same category, the date of entry into the service should be the determinant and not any other fortuitous circumstances. That is the law. And my second point, Lordship, I feel the affidavit of association, the respondent then would believe that it is not only the seniority, but other factors has been taken into consideration by the DBC. That is ACRs, service reports, awards. And this includes the submission of awards to the DBC. But at no point that time, Lordship, remarks in the ABAR, ACR has been communicated to the petitioner, which service report was also considered by the DBC, and recommendation was made in favor of respondent number 7.
What is your ABAR?
My ABAR was in my ABAR as per the reports enclosed by the respondents. My ABAR remarks column has been kept blank, nothing. So that case will apply, Lordship.
What case?
That case, non-communication of ACRs.
Oh.
So I'm challenging the seniority list, tentative seniority list.
Tentative?
Tentative. No, and second, in that way, Lordship.
That should be premature.
Ask, no, Lordship. Ask, because tentative seniority list has been considered by the TBC. And third point, Lordship. Ask for draft service law, which is not yet final, Lordship. For promotion, DBC should consider the final seniority list only, not tentative. But the tentative seniority was placed before the DBC, and DBC accepted the tentative seniority list in violation of the draft service law. So on two grounds, the promotion, the seniority list as well as the promotion of primary respondents was not sustained in that.
I'll come to you. I'll come to you. I'll come to you and you will make your submission on request. But yes, government, what is the ground for giving promotion to the respondent number 7 in supersession of the seniority of
Yes,
the petition?
may I please, Your Lordship, here, the petitioner counsel has rightly said that there is no service rule.
There is no service rule?
Yes, only draft. It is in the draft stage.
Hmm.
But my lord, as per for the promotion, the
When actually,
Your Lordship,
Mr. Government Advocate,
yes, my lord.
when there is no service rule,
Yes.
what is the criteria to determine seniority
My lord,
between
there is
two employees?
office memorandum, my lord.
What does your office memorandum says?
Office memorandum dated 1966.
1966, you still follow that?
Yes.
Are you sure?
That is in my paper, Lordship. 1966 OM.
What read?
Here, in the third rule 3, clause 1.
I have enclosed in my affidavit reply, Lordship.
Yes,
Yeah, let's read
for the
that.
promoters. There is two categories. One is direct recruitment and one is promoters. And the relevant portion is clause 3, 3 clause 1. The relative seniority of person promoted to the various grades shall be determined in order of the selection for such promotion. This shall apply to cases when promotion is made by selection by a departmental promotion committee. The seniority shall be in the order in which they are recommended for promotion by the departmental promotion committee. So, my lord, here, as per common order, that is order dated 24/10/16, both the private respondent and the petitioner were promoted by one common order. So now the petitioner, they're challenging only the seniority, tentative seniority list of Sabita Metro. So that is the selection post. Yes, selection post. That is the Sabita Metro. From there only it will promote to the higher post to the assistant commandant. So when there is common order, petitioner join later than the private respondent, because in the date of joining, petitioner was joined on 26/10/2016, and the private respondent was joined on 25/10/2016, 1 day prior to the petitioner joining. So as per since the selection post is Sabita Major, and they were promoted by one common order. So for the determination of the seniority, date of joining has been considered, my lord. As per the date of joining, private respondent has superseded the addition.
I think that is.
I have a citation for this, my lord, from the back spot, my lord.
Oh. That means just because the petitioner submitted the joining report in the promotional post,
Yes.
1 day behind the respondent number 7, he was superseded.
Yes.
That means you have erased all the seniority which he has held years back.
My lord, since
Will it not be justified?
If it is direct recruitment, then it should have been determined from the date of appointment.
No, he
promotion post.
He is a person. He is a person. The petitioner is a person who has been directly recruited.
No. From Chamatar, from the
How? Okay. Let us. You explain this.
Yes.
He has joined the post of Zamadar.
Yes. Sir.
From Zamadar to Subidar.
Yes. Sir.
How was the promotion made? From Zamadar to Subidar.
Yes.
How was the promotion made?
As per the seniority number.
As per the seniority.
Yes.
And from Subidar to Subidar Major.
Yes.
From Zamadar to Subidar, there was no DPC.
No, there was a DPC. DPC also. My lord, it's from promotion to the post of Chamatar to Sabidar, the selection post is Chamatar. So from there, from the Chamatar, among the Chamatar, they were promoted to Sabidar Major. And from the Sabidar Major to Sabidar Major, the selection post is Sabidar. As per the
No, from Zamadar, the next promotional post is Subidar. From Subidar, the next promotional post is Subidar Major.
Yes.
So from Zamadar, the petitioner first entered service.
Yes.
From Zamadar to Subidar, the petitioner was first promoted. And from Subidar to Subidar Major, the dispute starts there. Am I right?
Yes.
Yes.
But I think it is not proper to erase all his seniority. Yes, because one day, because maybe actually there are other factors like the petitioner must have been posted somewhere at a far off place. And the respondent number 7 might have been posted somewhere which was convenient to him to actually submit his report. All these factors the government should have taken into consideration. Being a welfare state.
I have made a categorical statement that I have received a promotion order on 26th and 2016.
You are also promoted now.
No.
You are not promoted. You are still Subidar.
Yes, Subidar Major.
Subidar Major.
Yes.
And respondent number 7 is?
Assistant Government. I'm challenging his promotion as well as the DBC and also the seniority list.
Subidar Major, the DPC of Subidar Major, you are challenging that?
No, DBC held for promotion to the post of assistant government.
Okay. So in the Subidar Major post also you were senior?
Subidar Major, we were promoted by command order to the post of Subidar Major.
From Subidar to Subidar Major, you were promoted by command order.
Yes.
But impliedly the seniority was maintained.
Yes.
Impliedly the seniority was maintained.
Yes. In fact, Lordship, they are training to the promoted post. They are submission of training which should not be a basis for the remuneration of interest in seniority.
You support your submission?
My Lord, as per the ruling laid down by the Supreme Court.
We will come to that.
Yes.
First, I want to know the facts.
Yes.
We will come to ruling. Obviously, we have to decide on the basis of the citations, the precedents laid down by the Honorable Supreme Court. But I want to know the facts. So the dispute is only from Subidar Major to Assistant Commandant.
Yes, my Lord.
Correct?
Yes.
Until Subidar Major, you were senior.
No, Lordship. The tentative seniority, imbued tentative seniority published by the authorities and the rank of Subidar Major. The proper respondent has been shown senior.
In the first, you were senior.
First.
In the first.
Second,
that is the seniority list of Subidar Major.
Yes.
First published.
Yes.
You were senior.
Yes.
Then afterwards it was rectified.
Yes.
No notice was issued to you. It was rectified.
Yes.
And thereby the respondent number 7 was placed as senior.
Yes. And DBC considered that imbued seniority list. Number 7.
Yes, Mr. Tumpok, in gist, what is your case? Let me just, before I start with the proper hearing.
Yes, just as our
Delay leases is his main condition.
Delay in leases. What is the year? What is the year?
2018.
That is the tentative seniority list.
Seniority list was published in 2018. The tentative seniority list.
Which was kept on this
The
post.
petitioner submitted representation. The present respondent submitted representation that his case he should be senior. Now
2018.
2018. In 2019, the second tentative seniority list came out, making the present respondent senior to the petitioner. Then in 2021, promotion was granted to the present respondent.
2021.
2021.
And when was this petition filed?
2022.
Then after, yes, in 2021, promotion was granted to the
There is no delay.
respondent, and then the petitioner approached his honorable court challenging the seniority list as well as the promotion of the petitioner. So now, Your Lordship, the promotion was considered on the basis of the draft service rules. The draft service rules.
What does the draft service rule says?
Yes, Your Lordship, the draft service rules, there are zones of consideration should be there. So 3 of us were considered, 3 for a particular post, even the petitioner.
And what was the criteria for considering you?
So the.
What was the criteria?
Was the.
Road servant class 3 of draft service law. That was seniority list and the upper.
Yes.
That is the criteria.
And among the three, the APAR is also all were submitted and based on.
Yes, government, whether you have made any statement in your affidavit that you have the government has the intention of following these draft service rules?
Yes, my lordship. Yes, my lord.
You have the intention?
Yes.
Oh, then why have you not published? When is the draft service rule dated?
Two 2014.
2014 and you have still not published?
Yes, my lord.
That means you don't have the intention of following the draft service rules.
Even otherwise, they violated the draft service law, provision of draft service laws, while considering the promotion.
Yes, what have you stated? Please read.
Para 7.
Yes, read.
But in regard to the statement made in para 8 and 9 of the writ petition, the answering deponent begged to state that admitted that the next line of promotional post is assistant commandant for Sabeta Major under the village guard organization. However, a service rule which is still in draft stage, namely Nagaland Draft Village Guard Service Rules 2014, is being referred to as a guideline for promotion to the next higher post of assistant commandant till finalization of the service rule. It may be pertinent to mention herein that seniority leads along with good APAR and integrity is also one of the mandatory requirement and component for promotion under every government institution. Hence, the contentions of the petitioner that there is no service rules governing the condition of the employees of the village guard organization and that promotions are effected basing on the general principle of seniority is misleading and untrue. The promotion of the respondent number 7 was initiated and given on the recommendation of the Departmental Promotion Committee basing on the record documents and certificates which seniority lists APAR integrity vigilance clearance. Hence, the condition of the petitioner of expecting promotion without any substance is amusing, my lord.
What is the APAR of the petitioner?
That one, my lord, we have not enclosed here in the.
Respondent 7 have enclosed.
What is the remark?
Remarks column just kept blank clause. So DBC considered that blank remarks. Remarks is not being communicated to the petitioner. As per the law, every remarks, whether it is good, bad, or better, best should be communicated to the employee's lordship.
And how your APAR is with respondent number 7?
I don't know, lordship.
Yes, government advocate, something is very fishy.
Yes.
You are respondent number?
7. It starts from this 37.
1, 2, 3, 4, 5, 6. Respondent 7. Page?
Page 38. Page 38.
This is
Overall grade for.
you are number 2.
Yes, lordship.
Hey, bhai.
That is what I am submitting, lordship.
It shows that his APAR was not maintained.
Your lordship, from the way he has been approaching this, from the manner that he has approached clearly shows that he's not concerned.
No,
Someone who was in the same way, we were all promoted in 2021. He was also among the superior majors. One Chon Konyak. He did not know that Chon Konyak was promoted together with me. From the way he has approached his court at this belated stage, Your Honor. They are serving together in the same, under the same commander in Mon.
Mr. Government Advocate, you file an affidavit as to why the APAR of the petitioner is blank. You file an affidavit. Because actually you are the custodian.
Yes.
Correct?
Yes.
You are the custodian of the APAR. So you should be knowing actually what is his APAR.
Yes.
Anyway.
That the Lordship fact remains that this award has been considered by the TBC. Without communicating these remarks to the petitioner, which is in violation of the law level by the apex court in the drug case.
No, it is not of non-consideration. You have no APAR.
Yes, okay.
You have no APAR. Have you seen page 38 of the affidavit filed by respondent number 7?
Yes, my lord.
How is this possible? It should be either good, bad, very good, excellent. But why blank?
My lord, in this regard, I will.
You have to.
Yes.
And if this be so, how did the DPC consider the APAR of the petitioner? If there was no APAR, it was incumbent on the DPC to have actually requisitioned the APAR. It seems actually the APAR of the petitioner was not at all called for. This shows. Yes, you produce the APAR.
Okay.
Okay, let him produce the APAR because I think something very strange is here. You are the custodian, correct?
Yes, my lord.
The learned government advocate shall on the next date produce the APAR of the petitioner without fail. Listed on?
A short date.
Yeah, listed on 19. Listed on 19/9/2023.
But, my lord, at least 2 weeks, my lord.
Why?
Because
2 weeks.
Commissioner, which is just next to this office.
Now, at present, the petitioner has been posted at Mon. So that APAR will be at
Okay,
Mon.
you may also be right.
Yes.
Okay, we will also take the convenience. Well, listed on 26th,
After 2 weeks.
Yes.
26th.
26.
Okay,
21 to 28, I'll be out of station.
21, 28.
Yes. 20,
30, Saturday, 29 is Friday. On 29, what's it? Friday.
3rd. Okay, listed on 3/10/2023. Please produce.
Okay, my lord. I'll do that.
Okay.
Yes, my lord.
Because actually this court finds something strange. So you produce the APAR. Let us see
Okay, my lord.
whether the APAR was also blank as projected by the DPC.
Yes.
Yes.
Okay.
That's all.
For hearing, item number 63.
Your Lordship, two.
What is the matter?
This is a very short matter so far as I'm concerned, Your Lordship.
What is that short matter?
The petitioner filing this writ, Your Lordship, they are challenging the preliminary inquiry conducted by the Lokayukta. Preliminary inquiry.
That is the only issue, whether that can be challenged. In fact, I have filed my preliminary objection also. This petition is premature because the order which has been passed by the Lokayukta is in connection with the preliminary inquiry. That is the only issue.
What order has been passed by the Lokayukta?
Your Lordship, the petitioners, three in number, they have filed an application seeking for copy of the complaint, the relevant records, and then whether sanction has been accorded by the state government and copy of that sanction. But so far as preliminary inquiry is concerned, Your Lordship, the sanction of the government is not necessary. And in fact, preliminary inquiry by its nature is discrete inquiry, Your Lordship. So furnishing copy of the complaint or documents is not necessary as per the Act. Your Lordship, I'll satisfy Your Lordship on that. So being aggrieved for not furnishing the copy of the complaint and then the copy of the approval accorded by the state government, which is not there, they have filed this petition. So my own preliminary objection is whether that can be.
So your inquiry may end up in favor or against?
Sure. That is.
At 2?
At 2, Your Lordship.
Okay, we'll resume at 2. Yes, Mr. City.
May I place on note?
Yes.
This matter, really, the petitioners are challenging the jurisdiction of the Lokayukta. There are 3 writ petitioners. All are under verge of retirement. Release order has already been issued by the department, but it is next year only. Circular has been issued by the department recently, showing the date of retirement as 31st May 2024. And that was counted from 1989. All along, although the petitioners for some time, they were appointed as part-time, they were engaged sporadically, and then since there was no other records, their service were counted from 1989. Department, all along they have been maintaining, and department has no problem with that. Now, some employees in the department were made to retire. And they claim that we are also similarly situated with those persons, but those persons are allowed to remain in the service, and we were made to retire by applying a different yardstick. That must be the possible reason. Apparently, those people who are who feel to be deprived, they have filed an application, complaint, maybe before the Lokayukta, that look, some inquiry is necessary on this. So we were served with summons by the Lokayukta that look, some complaints have been received. So they were requested to appear before the Lokayukta, Lokayukta. So petitioners do not know for what purpose they were summoned, so they went and just setting the summary lordship, so that lordship will grasp what is the matter about. So it was discovered that they were summoned in connection with a complaint lodged by some of the employees who have already been retired. So we wanted to have a copy of the complaint. Okay, if there is any complaint against us, at least furnish a copy of that complaint. I want to see what is the allegation in that complaint. We were denied of that also. And then we were asked to appear again and again. That's how we have approached this honorable court that look, Lokayukta has the power to do investigation, and they have every power to see and investigate in connection with the Prevention of Corruption Act and the corruptions committed by the government servants. If they indulge in such practices, yes, they have the power to do this. But the present matter is a matter with regard to the computation of the length of service for the purpose of retirement. For that, Lokayukta do not have any authority and power to investigate by taking cognizance on a complaint and to conduct investigation. So having agreed by this, we have the 3 petitioners have approached this honorable court on the ground that under the second schedule, Lokayukta do not have the power, no jurisdiction. You have exceeded the jurisdiction. What vested interest do you have to investigate this issue? Well, the department do not have any issue. Department is saying that from the records we have verified, and the data tuning and data computing, the period of computing will commence from 1989, in which case they will retire in the year 2024 on 31st May next year. And release order has already been issued in respect of all the 3 employees during the pendency of district petition lodge. So when the matter is very clear that the Lokayukta do not have such power to do investigation in a service matter, more particularly with regard to the computation of the length of service, when department do not have any complaint. So that is the short matter in the short canvas where this honorable court may consider this particular petition, Lordship. Now, can we come to the appointment? Because little background will be necessary. From time to time, sporadically, they were engaged.
Your Lordship, my preliminary objection is there. Let that objection be kept open.
And we were appointed on work charge. And page 17. This is the type copy. Of course, the letters are very small. This is in respect of petitioner number 1, Catherine Chebichu, temporarily appointed on a work charge basis in the Directorate of Agriculture in the scale of so-and-so. And then this is the appointment order. In respect of petitioner number 1. And in respect of petitioner number 2, petitioner number 2, Lordship will find
Let us read that page 17. Let us
17. Okay.
Let me be also clear.
Yes. May I read, Lordship?
Yes.
In the interest of public service, Ms. Catherine Chebichu is hereby temporarily appointed on work charge basis to the Directorate of Agriculture in the scale of pay of so-and-so, inner line compensatory allowances under basic pay subject to maximum of rupees 400 per month and all other allowances as admissible under the rules from time to time enacted in the similar cadre with effect from the date of joining. The appointment is made purely on temporary basis for a period up to, and it is not legible, and may be terminated any time without assigning any reason.
What is the post to which this petitioner number 1 is appointed?
LDA district, Lordship.
LDA district?
Yes.
Where is it stated?
On the work charge.
Where is it stated? When the public interest is hereby temporarily appointed.
In the appointment order, it is not very legible. This one is
appointed as?
And the posting was given in the district.
As what?
On work charge basis.
No, as what?
LDA.
How do you get that LDA from?
In page 18.
18.
Yes. This is in respect of petitioner number 2.
LDA.
Appointed as LDA. So, in the same manner, the petitioner number 1 was also appointed.
Okay. So 18 is the petitioner number 2.
Yes. That copy, Lordship, will find in page 19.
Yes.
And then page 20 is in respect of petitioner number 3. Appointed as LDA district. That copy is in page 21.
Okay. Okay.
And then page 23. This is a common order in respect of all the petitioners. They were again appointed on the work charge basis.
Yes.
This is 15 July 1986.
Yes.
Yes. And then page 24.
Yes.
Annexure E.
Yes.
This is in respect of all the petitioners. This is also a common order. The services of the following are hereby appointed as LDA Directorate against the newly created post of cashier in the scale of pay of rupees so-and-so, basic pay and all other allowances as reprehensible under the rules from time to time in Nagaland in the similar category with effect from 1/6/1989. And the name of the incumbents are shown. Serial number 1 is petitioner number 2, serial number 2 is petitioner number 3, and serial number 4 is the petitioner number 1.
Yes. Not on temporary basis and liable to be terminated because the post were created. Okay.
And then can they come to page 26? This is a typed copy of Annexure F dated 2nd December 2021. By this page 26. Circulation of a combined seniority list where the particulars, date of entry, due date of retirement, Lordship will find there. May I read, Lordship? Page 26.
Yes.
This is 2nd December 2021. The final combined seniority list in respect of class 1 and 2 gazetted officers and ministerial staff in the Department of Water Resources was on 1/8/2021 is hereby notified to all the concerned as per annexure enclosed.
They were by this page.
Page 26.
This is page 24 is in which department?
This is regular appointment, Agriculture, Department of Agriculture. Lordship, it was issued by the Joint Director, Irrigation, but then on the top, it is written as
Agriculture.
Department of Agriculture.
Okay. So this is water resource.
Yes.
So this is after bifurcation?
Yes.
Bifurcation of Agriculture Department?
Yes. Lordship is on page 26.
Yes.
May I read, Lordship?
Yes, please.
Because this will be relevant.
Yes.
The final combined seniority list in respect of class 1 and 2 gazetted officers and ministerial staff in the Department of Water Resources was on 1/8/2021 is hereby notified to all the concerned as per annex enclosed. The final seniority list nullifies all previous seniority lists under the department with immediate effect and shall henceforth be used for all official purposes till such time the government decides to revise, update the list. So by this, everything has been finalized. And then the next page, page 27, the particulars are shown. And serial number 1, 2, and 3 are the petitioner number 1, 2, and 3 respectively. And in respect of petitioner number 1, that is serial number 1, Shrimati Catherine Chebichu, date of birth is shown, graduate, and date of training service, that is 1/6/1989.
That is
page
24.
Yes, page 24.
1/6/89.
Yes. In respect of all the 3 petitioners, same date of training. And accordingly, the date of retirement has also been already issued in respect of all the 3 officers.
Date of counting, date of subsequent appointment, okay. Date of appointment, date of joining service, date of counting seniority. Date of counting seniority.
That is in the present grade.
In the present grade of?
The serial number 1, that is the petitioner number 1.
UDS.
She is registered now. The training, yes.
But actually this seniority was when actually the petitioner number 1 was the appointed serving as superintendent. Correct?
Yes, registrar.
Superintendent, 1, 2, superintendent. Oh, register.
On the top, registrar, and then other two.
Yes.
At present year, superintendent, both of them.
So this is counting the date of seniority as register and superintendent.
Yes,
Is
yes.
it?
Yes. And the date of joining the service is same in respect of all the three. That is in terms of the order dated 1/6/1989.
Yes.
And then next page, page 28, that is the summons. The real show will start from here, Lord.
Page 28.
Page 28, Annexure G, and it is dated 17 October 2022. This is a letter written by the Director and Deputy Inspector General of Police, Nagaland Lokayukta Police, addressed to the Chief Engineer, Water Resources Department. This is subject is summons under section 17, clause 2A of the Nagaland Lokayukta Act 2017. Sir, with respect to the subjects headed above, it is requested to direct Srimati Kiholi Sima, Superintendent, Directorate of Water Resources, to report before Shri Wapong M. Song, investigating officer in Nagaland Lokayukta Police Station, Kohima, on 18 October 2022 at 11 a.m. without fail. Your cooperation on the matter is solicited. A similar letter has been issued to all the three petitioners, Lordship. And pursuant to this, the Chief Engineer, that is the head of the department, Water Resources Department, Nagaland, on the same date, has replied to the summons,
which
Lordship will find at page 29. To Director and Inspector General of Police, Nagaland Lokayukta Police. And the subject is given. Sir, in response to your letter number so-and-so, dated 17 October 2022, I am directing Srimati Kiholi Sema, Superintendent, under the Office of the Undersigned, to report before Shri Wapong Song, Investigating Officer, Nagaland Lokayukta Police, Kohima, on 18 October 2022 at 11 a.m. This is for your kind information. And copy 2 was given.
Just wait.
Copy was given to the officers concerned. On the next page, page 30.
Just wait. Page 29.
Yes.
Is the.
That is by the Chief Engineer, Water Resources Department, informing the department about the steps taken by him, directing the officer to appear before the Lokayukta.
Yes.
Page 29 is in respect of Srimati Kehole Sema, and page 30 is in respect of the other two, petitioner number 1 and 3. Similar letter was sent.
Yes.
Page 31 is also by the chief engineer.
Yes.
About sending the officers for appearance before the Lokayukta. This is on 28 October 2022.
Yes.
And then representations have been submitted by the petitioners. So that was forwarded by a letter dated 24th November 2022 by the additional chief engineer, Water Resources Department, to the Director and Deputy Inspector General of Police, Nagaland Lokayukta. That is page 32, Annexure I, 24th November 2022, where the representation has been forwarded. And the representation also will find in the next page. Similar representations have been submitted. Therefore, let me refer to only one.
Page 32
yes.
is the letter written by Additional Chief Engineer.
Yes.
Forwarding the representation.
Yes.
Then the next is request.
This is the representation.
Which one?
Page 33 is the representation.
No. There is no representation in my copy. No. Just give him. Yes, sure.
This is the one.
This is the one.
This is the one.
Oh, this is
the 3rd November is the representation date, and the forwarding letter is on 24. Actually, it should have been reversed while enclosing the copies.
So this is a request
for. Third should have come first. So this is the representation.
No, representation means. What?
Representation.
Your page 33.
Yes.
You just read.
Request for a copy of the complaint or charge, if any.
So this is not representation.
In the form of a representation, they have.
I was thinking the representation which you had submitted to the to the director.
They have treated this as a representation. That's why in the forwarding of representations,
to
the subject itself is given like that.
This is seeking for a copy of the complaint.
Yes, Lordship is correct. We sought for a copy of the complaint. Similar application has been submitted.
Then 34 same.
May I read, Lordship?
Yes.
Page 33.
Yes.
Request for a copy of the complaint or charge, if any. Sir, on the subject cited above, I beg to state a few lines for your perusal and necessary action on the following. That Shri Wapungemso, investigating officer, Nagaland Lokayukta Police Kohima, has on several instances taken all my files from the Water Resources Department. 1. That I have also sent summons and statements were kept from me.
Were taken from me.
That I have rendered my utmost cooperation to the investigating officer till date. 3. That no complaint letter or charge has been issued to me till date. 4. That I have requested the investigating officer orally for a copy of the complaint, if any. Excuse me. At the time of giving my statement, to which he has stated that I I have no right to ask for a copy of the complaint. Therefore, I request your office to kindly issue me a copy of the complaint or general or specific approval by the state government to investigate me, for which I will be aware. For that reason, I am being investigated. So, approval of the government is also required for conducting the investigation and inquiry also. That was not obtained. But just because some complaint has been filed by some individuals, summons have been issued. So we feel a little fishy, something must be wrong. And this is not the way how a proper investigation can be conducted, more particularly by the Lokayukta, when they are invested for some other purpose, not to conduct investigation in a service matter. If we have committed any corrupt practice in the course of our service, yes, no doubt, Lokayukta job is for that. But if there is no charges of corruption or complaint, then for a mere service matter, it is not a function of the Lokayukta to conduct investigation. So we sought for a copy. Who has complained? What is the complaint? At least I should get an opportunity to know about all this. But that was not furnished even till date also, which we have sought for. And then we were heard, and the order lordship will find it page 36. And actually check. It is ordered at 7/12/2022. May I read, Lordship, this? We are challenging this.
Yes.
May I read, Lordship? The Nagaland Lokayukta is conducting a preliminary inquiry based on a complaint that the following government servants, namely Srimati Catherine Zevichu, Registrar, Srimati Keholi Sema, Superintendent, Srimati Rokulano Muru, Superintendent of the Directorate of Water Resources Department, are overstaying in their services, having been appointed in 1983, thereby attracting relevant sections of the Nagaland Retirement from Public Employment Act 2009, and further, allegation that this issue was examined by a committee constituted by the government, and the committee, having examined all relevant documents, has recommended the three above named employees apply for voluntary retirement, despite which they continue to be in service. The said three employees under inquiry has petitioned these organizations to issue a copy of the complaint, copy of specific approval of the state government to investigate them. The Nagaland Lokayukta functions under the Nagaland Lokayukta Act 2017. The said act extends to the whole of Nagaland, state of Nagaland, and applies also to the public servants posted outside Nagaland in connection with the affairs of the state of Nagaland. The said act provides which matters may be investigated and matters not subject to investigation. The instance case is outside the review of Section 9 of the Act, which provides certain matters not subject to investigation by the Nagaland Lokayukta. Hence, the preliminary inquiry shall continue to its logical end.
Just read this again, the instant case.
The instant case is outside the review of Section 9, because Section 9 is the exemption, and they are saying that it is outside the exemption, so they can do it. That is what they mean to say. Outside the review of Section 9 of the Act, which provides certain matters not subject to investigation by the Nagaland Lokayukta. Hence, the preliminary inquiry shall continue to its logical end. They are saying that it is just a preliminary inquiry, so we have the power. That is what they try to justify. And hopefully my learned friend is prepared on that. May I continue, Lord?
Yes.
Section 35 of the Nagaland Lokayukta Act provides that the provisions of the Anti-Corruption, Grievance Redressal and Whistleblowers Protection Act 2011 shall apply mutatis mutatis to the state of Nagaland. Section 13 of the Whistleblowers Protection Act 2011 is that the competent authority shall, notwithstanding any law for the time being in force, conceal as required under this Act the identity of the complainant and the documents or information furnished by him for the purposes of inquiry under this Act. Inquiry under this Act that is relevant, unless so decided otherwise by the competent authority itself, or if if became necessary to reveal or produce the same by virtue of the order of the court. In view of the aforesaid provisions of law, the petitions of the 3 employees under inquiry is not considered. The CDC of this court order to each of the petitioners and to the additional chief engineer, Water Resources Department. So they don't want to divulge who is the complainant. They don't want to furnish what is the complaint against them. Now, before I go to the relevant provisions, let me come to the pleadings from paragraph 11 to 17. This is the foundation and basis of my case. Instead of repeating again and again, I would like to just rely on those pleadings. This is more authentic and everlasting ones. So, may I take your Lordship's attention to page 10, paragraph 11. May I read, Lordship?
Yes.
That the petitioners speak to state that the petitioners are not disputing about the exclusion of their past service for computation of length of service, as such exercise is to be carried out by the competent authority in terms of the relevant provisions of law in operation. However, the fact remains that petitioners have not indulged in any corrupt or illegal practices to gain such benefits, but the respondent number 1 had proceeded to initiate the inquiry against the petitioners as if such corrupt practice was committed by the petitioners, resulting in the exclusion of their past service for computation of the length of services. The service of the petitioners were counted from the date of their regular appointment as by the competent authorities mentioned in their aforesaid appointment order, and the same has been recorded in all their service documents, and as such, there is no foul play or corrupt practice on the part of the petitioners to manipulate the records with the intent to remain in service for a long period. Therefore, in the absence of any criminal element or intent, an offense under the Nagaland Lokayukta Act and Prevention from Corruption Act 1988 and Whistleblowers Protection Act 2001 is not attracted to prosecute the petitioners. So, ingredients, what are required, I have mentioned in this paragraph, and the Act and sections which they are relying are not relevant and applicable so far as the petitioners are concerned in view of the absence of the ingredients required for preliminary investigation by Lokayukta. Paragraph 12. That the petitioners speak to state that it is the responsibility of the competent authorities to issue appropriate formal orders and notify the same to the concerned employees about their due date of retirement well in advance, and as such, the petitioners cannot casual manner let their services without appropriate formal order from the concerned authorities. Therefore, the petitioners are being unreasonably dragged into the proceedings by the respondent number 1 without any fault on their part.
the fact that the petitioners are still in service, as the concerned authorities has computed the length of service from the date of their regular appointment as recorded in all their official documents, and as such, the computation of the length of service of the petitioners is not the responsibility of the petitioners, and as such, it should not be attributed to the petitioners. Now, whatever may be the manner of computing, if it is the petitioner who is doing, then yes, I may be penalized for that. But when the authorities have already done, based on the record, done something, taken some steps and decisions based on the record, for that action, how the petitioners are responsible. If I allowed to remain in the service without allowing me to go by the authorities, can I just know I'm going bye-bye? No. And that is what they are insisting. That no, you should have gone. Why you are remaining? I have to go as per the government order. I'm a government servant. So whatever the government directs, I have to follow. I have to comply. That is what we are doing. And Lokayukta is saying that no, you cannot comply and listen to the government. That is what they are doing, Lordship, here. May I proceed further? Paragraph 30. That the petitioners speak to state that the petitioners have not caused any damage or prejudice to any person, nor have acted in malicious and vexatious manner, so as to attribute to such allegations and such complaint were made by unknown persons who are not agreed parties as contemplated by the Prevention of Corruption Act 1988 and or the Nagaland Lokayukta Act, but further unduly caused mental harassment and humiliation to the petitioners. 14. That the petitioners speak to state that, in addition to the power of limitation, the second schedule of the Nagaland Lokayukta Act 2019 at clause D specifically bars inquiry into the service matters subject to the exceptions contained therein. Clearly, the action taken against the petitioners by the Nagaland Lokayukta is illegal, frivolous, and without jurisdiction in terms of the proceed provision. That is the second schedule of the Lokayukta Act 2019. And exercise of power without jurisdiction is of an issue and is liable to be set aside and quashed by this Honorable Court. Paragraph 15. That the petitioners speak to state that the entire proceedings initiated by the Lokayukta was done without serving the charges against the petitioners, and as such, the petitioners are still kept in the dark completely unaware of the specific charges as for which they have been prosecuted, resulting in complete disregard to the Constitution and the constitutional safeguards. 16. That the petitioners speak to state that allegations against the petitioners does not fall under the ambit of corruption, and the subject matter is, there are two is not. Subject matter is not to be adjudicated by the Lokayukta Nagaland, and as such, the action of the respondent number 1 is wholly without jurisdiction and illegal and in violation of the rights of the petitioners guaranteed under the Part 3 of the Constitution. Paragraph 17. That the petitioners speak to state that Section 8 of the Nagaland Lokayukta Act 2017 prescribes for seeking the prior sanction of the government to hold any inquiry or investigation to be conducted against any government servants, which was completely violated by the concerned authority. Thus, the action of the respondent number 1 is in violation of the procedure laid down by the Act. So this ground itself is good enough. And if at all they have taken the permission of the government, let them say, but I'm making a submission, I'm making a categorical statement that this provision has not been complete. This itself is a ground to quash the ongoing proceedings. And
let us see that
provisions.
Let us see that the 14, para 14.
Para 14.
Nagaland Lokayukta.
Yes, second schedule.
Let's see.
Lokayukta Act. towards the end, Lordship will find.
Second schedule.
Second schedule. See section 9, clause 1, sub clause A. And D will be what? Fourth paragraph, Lordship. D. Action taken in respect of appointments, promotions, pay, discipline, removal pay, discipline, subordination, or other matters relating to conditions of service, public servants, but not indulging action relating to claims of pension, gratuity, provident fund, or any claim which arise on retirement, removal, on termination of service, and such other action involving allegation of corruption in respect of appointment not filed under the provisions of section 35 of the Act. So, under these provisions, they do not have the power. They may do some investigation if there is allegation of corrupt practice. But by listening to the government orders, what kind of a corrupt practice the petitioners have committed? The area of the case, the issue, is very, very limited and confined to a small area that is on this jurisdiction. If the petitioners...
Let's read once more, D.
Yes.
D once more.
Action taken in respect of appointments, removal, pay, discipline, subordination, or other matters relating to conditions of service of public servants, but not including actions relating to claims for pension, gratuity, provident fund, or any claim which arise on retirement, removal, on termination of service, and such other action involving allegation of corruptions in respect of appointment, not part under provisions of section 35 of the Act.
So what it conveys?
Section 9.
No.
Can you come to section
D what it conveys? Does it mean to say that in respect of appointment, removal, pay, discipline, subordination, or other matters relating to conditions of service of public servant, this will not be investigated by Lokayukta?
Yes.
Does it mean to say that?
Yes. Because for that, we have to come to section 9. As clearly shown in the second schedule, just below that second schedule, see section 9, clause 1, sub-clause A. So kindly come to section 9.
Matters not subject to investigation.
Yes. We are concerned with clause 1, sub-clause A. If such action relates to any matter specified in second schedule that is not subject to investigation. So, clause A, if such action relates to any matter specified in second schedule. So, we have to see the second schedule. These are not subject to investigation.
What is section 35? What is section 35 of the Act, Mr. CT?
35.
Yes.
That is with regard to the whistleblowers.
Whistleblowers Act 2011. That will.
Go there. Lokayukta is saying that Whistleblowers Act is applicable and Prevention of Corruption Act is applicable.
So what Lokayukta is saying is that the persons who had made complaint against this petitioners, they are whistleblowers.
Yes. Therefore, it is not subject to disclose. That is what they are trying to say. And second aspect is, Lokayukta is saying, this is just a preliminary inquiry, preliminary investigation. Lokayukta has the power to do this. So on that point, my only reply is simple reply. Okay, if you are saying that this is only a preliminary investigation, that means had it been a regular investigation and inquiry, we do not have power, we may not have power, but if it is only a preliminary inquiry, then we have the power. That is what they mean to say. But my answer to that argument is, if you do not have the power to investigate and make inquiry, even on a regular basis, in normal course, what power do you have even to conduct a preliminary inquiry and preliminary investigation? It's all the same. Regular inquiry, regular investigation will be based on the preliminary investigation and inquiry. It amounts to say that, okay, you have committed the offense of thief. No, I have committed thief only by stealing one needle, one pin I have stolen. That is very negligible and minor. Those things cannot be treated as a thief, and I cannot be penalized for offense of thief. If I stole some huge amount of money, if I stole gold or some valuables, then I can be investigated and I can be held punishable for that. It amounts to saying like that. In the same form, they are coming with that argument also. And to me, such argument is not sustainable and not relevant to our context. One can say anything, one has the right to say and submit also, but whether such a submission will be relevant or accepted, Lordship can also consider the relevant provisions and take a decision. My submission is very simple, that in this matter, the Lokayukta do not have the power to investigate, giving in view of the provisions, different provisions. And their contention is not sustainable also. And the two acts, the Prevention of Corruption Act and the Official Powers Act, these two are also not relevant, giving in view of the subject matter of our case. I think I have filed a reply, so I will give reply after.
You were actually, Mr. CT, you were actually making a mention that the department has already issued the order for your superannuation. Can I kindly have that?
Yes, sure, Lordship.
And please give a copy also to Mr. TB.
Yes, sir. It was issued on 30th May 2023 as per the normal government order. This should be the way how a person should be informed well in advance about your retirement. There are 3 pages. The first page is about the retirement in general, and the second page is there's some correction is there by way of a corrigendum, which was also issued on 8 June 2023. And then
this second page is with regard to the
some corrigendum that they are on completion of 35 years of service. So, in respect of 2 officers of pension, serial number 1 is not relevant.
2 is relevant.
But 2 is relevant, that is the petitioner number 1.
Then petitioner number 2 and 3.
And then in the third page, in the chart,
yes,
Lordship will find on the extreme left serial numbers are given.
Your serial number
9
is also
10,
harassed.
and 11.
Which you just tell by name because the serial number is not legible.
Yes. Just about 12.
12.
Three names. So, Srimati Catherine Chibichu.
Srimati Teholi Sema.
That is, yes, petitioner number
And then
2.
Catherine Zavichu.
Yes. And Srimati Rokolano.
Okay.
3 of them, 9, 10, and 11. So on the extreme right column, the second last column, Lordship will find just below the annexure 1, date of release on completion of 25 years of service. That is
31.5.
Yes.
Then next also, Teholi also 31.5.
Yes.
Then Rokolano also 31.5.
Yes. All of them are retiring on the same day. This is the order issued by the competent authority, and what the Lokayukta is saying is we should have gone earlier. If you want us to go, if the government asks me to go, I can go. I'm a mere government servant. I'm bound by the government orders and rules. So if they are retaining me in service, basically on the record, I cannot say that you apply your orders and I'm going. I cannot do that, Lordship. So we have to comply with the orders passed by the competent authority, and that is what we are doing. And they have issued the.
Can you kindly take this code once again to the order passed by Lokayukta?
Yes, Lordship.
The order passed by the Lokayukta. Let us read once again.
Page 36.
Yes. Kindly read that.
The Nagaland Lokayukta is conducting a preliminary inquiry based on a complaint that following common servants, namely Srimati Catherine Chibichu, Register, Srimati Kehole Sema, Subandhan, Srimati Rokulano Muru, Superintendent of the Directorate of Water Resources Department, are overstaying in their service, having been appointed in 1983, thereby attracting relevant sections of the Nagaland Retirement from Public Employment Act 2009, and further allegation that this issue was examined by the committee constituted by the government, and the committee, having examined all relevant documents, has recommended that 3 above named employees apply for voluntary retirement, despite which they continue to be in service. The said 3 employees under inquiry has petitioned this organization to issue a copy of the complaint, copy of specific approval of the state government for investigating them. The Nagaland Lokayukta functions under the Nagaland Lokayukta Act 2017. The said act extends to the whole state of Nagaland and applies also to the public servants posted outside Nagaland in connection with the affairs of the state of Nagaland. The said act provides which matters may be investigated and matters not subject to investigation. The instant case is outside the purview of Section 9 of the Act. Section 9 is the exception clause, which provides certain matters not subject to investigated by the Nagaland Lokayukta. Hence, the preliminary inquiry shall continue to its logical end. Section 35 of the Nagaland Lokayukta Act provides that the provisions of the Anti-Corruption, Grievance Redressal and Whistleblowers Protection Act 2011 shall apply mutatis to the state of Nagaland. Section 13 of the Whistleblowers Protection Act 2011 is that the competent authority shall, notwithstanding any law for the time being in force, conceal as required under this Act the identity of the complainant and the documents or information furnished by him for the purpose of inquiry under this Act. For the purpose of inquiry under this Act, unless so decided otherwise by the competent authority itself, or it become necessary to reveal or produce the same by virtue of the order of the court. In view of the aforesaid provisions of law, the petitioners of the 3 employees under inquiry is not considered. The CDC of this order that is pertaining to others. More or less.
Do you have this whistleblowers?
Just send
Yes, please.
just sent to the library.
Okay, please. Yes, Mr. Siki.
So the individual order is more or less on a representation which we have submitted, asking for a copy of the complaint and disclose who is the complainant, who has filed this complaint, and what is the content of the complaint. So, and that the Lokayukta has passed this order. In fact, it was Upa Lokayukta. So, from the very nature and manner of the case, what I could suspect is it is a stage managed investigation that, okay, you submit an application, a complaint, I'm there, I will investigate. That is what it demonstrates from all the sequence of events and the documents, which is not permissible in the eye of law. And one important thing is that there is no allegations or complaint or charges from the department concerned. And when the concerned department has no complaint or grievance against the action committed by 3 petitioners, what business the Lokayukta has to conduct an investigation also, more particularly with regard to the computation of length of service. In connection with the irregularities in computation of the length of service.
Yes.
So for Lordship, the ongoing investigation is not authorized by law, so it is liable to be quashed, Lordship, and referred by this honorable court. I conclude my submission.
Mr. TB, you have for respondent number
1 for a Lokayukta motion. May I please, Lordship?
Yes, yes.
Lordship, I have raised preliminary objection on maintainability. My preliminary objection on 2 grounds. The first ground, Your Lordship, is that petitioner has no right, no legally enforceable right to challenge and to pray for quashing of preliminary inquiry. Second objection is, Your Lordship, the petitioner has no legal right to be furnished copy of a complaint in connection with preliminary inquiry, Your Lordship. Those are the 2 grounds which I have taken. But before I take Your Lordship to my preliminary objection, Your Lordship, if my Lord may kindly bear with me, I would like to satisfy Your Lordship on the jurisdiction of the Lokayukta, which goes to the root of this matter, Your Lordship. Because ultimately, it all boils down to the jurisdiction. Now, if my Lord may kindly note down, Your Lordship, under the Act, Lokayukta has jurisdiction to investigate 3 categories of complaint. 3 categories, Your Lordship. The first is complaint involving allegations.
Which is the provision?
I will be coming to that. I will take Your Lordship to the Act. Complaint involving allegation under the Prevention of Corruption Act 1988. Second is complaint involving grievance. That is the second category of complaint which Lokayukta can investigate. And third category, Your Lordship, is complaint involving disclosure on allegation under the Whistleblowers Act 2011. And that these are complaints received apart from the jurisdiction of Lokayukta to investigate any matter so moto. Jurisdiction on its own it can investigate, Your Lordship. Now may I take Your Lordship to the relevant provision. of the PC Act, Lokayukta Act 2017, Your Lordship. Section 2F. This is the first category. Section 2F of the Nagaland Lokayukta Act 2017, Your Lordship. Section 2F. It defines complaint involving allegation under the PC Act. F, 2F. 2F. My Lord has got it? Yes. Yes. Now, complaint means a complaint made in such form as may be prescribed, alleging. This is complaint involving allegation, Your Lordship. Alleging, this word is relevant, Your Lordship, that a public servant has committed an offense punishable under the PC Act 1988, Your Lordship. Now, I have given the PC Act, Your Lordship. If my Lord may kindly go through that also. PC Act, Chapter 3. It starts from Section 7 to 16. Section 7. This is Chapter 3. Section 7, Your Lordship. I will just read the head note to save time, Your Lordship. Section 7. Section 7 of the PC Act. Chapter 3 deals with offenses and penalties under the PC Act. Now, Section 7, my Lord has got it. This is offense relating to public servant being bribed. 7A, Your Lordship, taking undue advantage to influence public servant by corrupt and illegal means by exercise of personal influence, Your Lordship. Section 8, offense relating to bribing of a public servant. Section 9, Your Lordship, offense relating to bribing a public servant by a commercial organization. Section 10, person in charge of commercial organization of being guilty of offense. Section 11, public servant obtaining undue advantage without consideration from person concerned in proceeding or business transacted by such public servant. Which is the relevant provision you want to relate. Now, what I would like to impress upon Your Lordship is that offenses under the PC Act involves gratification, misappropriation by public servant, that is one, and also against any private person, may not be public servant, who influences public servant by corrupt and illegal means. Exercise. That is what those are the offenses under the PC Act, Your Lordship. Now, may I take Your Lordship to complaint involving grievance. What is grievance? Section 2G. Grievance means definition under the Lokayukta Act, Your Lordship. 2G. 2G. Yes. My Lord has got it. Grievance means a claim by a person that he suffered injustice or hardship as a consequence of maladministration. And maladministration, Your Lordship will find at Section 2K. What is maladministration? Maladministration means action taken or purported to have been taken or failed to have been taken where such action or 2K, Your Lordship. May I read out? Maladministration means action taken or purported to have been taken or failed to have been taken where such action or failure is unreasonable, unjust, oppressive, or improper, or discriminatory, or with undue delay or negligence or destructive of procedure, practices, etc., governing such actions. So these are the two: one complaint involving allegation and one complaint involving grievance, Your Worship. Now the third category, may I take Your Lordship to Section 35? What do you mean to say? Now these are the two categories of complaint which the Lokayukta. May I take Your Lordship to section for more clarification, Your Lordship? May I take Your Lordship to Section 9.3? How this complaint is to be taken?
Complaint in what context?
Yes, section 9.3. Here, complaint involving allegation, in the course of my
Section 9?
9.3. 3A. 3A and B, in order to clarify regarding complaint involving allegation and complaint involving grievance, Your Worship. And I will further clarify with case laws, Your Worship. Your Worship, I will make Your Worship understand, Your Worship. Actually, these are limitations where 3A says any complaint involving a grievance. The grievance is defined in section, in the definition portion, Your Worship. And 3B relates to complaint involving allegation. So these are the two types of complaint which Lokayukta can investigate. I will satisfy Your Worship with case law. Now for the time being.
No, I have still not understood what you are submitting.
What I am submitting, Your Worship, what are the categories of complaint that the Lokayukta can investigate? One is complaint involving allegation under the PC Act. Whether Your Worship understood that. Right?
This is not applicable.
Now, second, complaint involving grievance. And grievance may be because of maladministration.
This maladministration should relate to the person who is aggrieved.
Exactly. That is the thing. That is the thing. And complaint, in the complaint there may be allegation and there may be grievance. A complaint may have both. For Your Lordship, satisfaction may take Your Lordship to at this time similar matters were dealt with by the division bench of Bombay High Court. In Vishwasraj's case,
before case law, you please satisfy me on your case.
Just on complaint involving allegation and complaint involving grievance. What is the difference?
One is complaint
involving allegations, and what is complaint involving grievance. Let me satisfy Your Worship on that. In Vishwasraj case, Patel's case, Bombay High Court. Just one paragraph, Your Worship. Paragraph 17. Of paragraph 15 and 17, may I take Your Worship to paragraph 15? This is also against Lokayukta, Your Worship. My Lord has got paragraph 15. Further, in our view, in a given case, an action may constitute both grievance and an allegation. In some cases, the action may amount to allegation and its consequence might result in grievance. The overlap is inevitable, as in the case the definition emphasizes the consequence of an act, in the other, the motive for it. May I take Your Lordship to paragraph 17?
The 16, what about 16?
16, I'm just reading the relevant portion. These are the allegation grievance definition as in our PC Act, Your Lordship. It's in our Lokayukta Act. Paragraph 17. The main contention raised before us as well as before the Lokayukta was regarding the jurisdiction of the Lokayukta to entertain the complaint filed by Dr. such and such. It is not necessary to make a detailed reference to the affront or allegation made in the complaint since they are properly catalogued by the Lokayukta in para such and such. Number one, Dr. such and such had been called for interview for the post of additional honorary such and such in the Government General Hospital at such and such. Number two, respondent 1 to 3 had issued.
He was not qualified for that post.
Yes. Respondent number 1 to 3 had issued such and such. By abusing their position.
Do you think this facts will support your case?
I'm coming to that, Your Lordship. If Your Lordship may kindly bear with me. Now here, Your Lordship. Now 1, 2, 3, 4. Look, it has been catalogued. Now, next paragraph. Reading the allegation made in the complaint, it can be said that the averment made in subpara 1, 3, and 4 might fall within the area of grievance. However, the averment made in subpara 2 about the abuse of position by the public servant to favor the petitioner squarely falls within the scope of the term allegations. What I would like to impress upon Your Lordship is that complaint involving allegation, complaint involving grievance, they are two separate. Lokayukta can investigate both the complaints. Complaint involving grievance and complaint involving allegation. Well, Lord Senior Counsel, he has taken Your Lordship to section 9.2, where exemption is there. Wait a minute. Section 9.2. Read which second schedule? Section 9.2, Your Lordship. If my Lord may kindly read section 9.2, 9.1, where matter, section 9, matter not subject to investigation.
Section
9.1. Lordship has got it? Except as herein provided, the Lokayukta or Lokayukta shall not conduct any investigation under this act in the case of a complaint involving grievance. Lordship may kindly mark that. Complaint involving grievance, complaint involving allegation is totally different. And the issue here is complaint involving allegation, not grievance. There's an allegation that the petitions have been allowed to continue. So what is this section 9 to relied upon by the petition is not applicable at all.
Is there any complaint from the department, from the government?
Lordship.
Is there any complaint from the department, from the government?
Yes. Now
the government has already issued the orders.
I'm coming to the third category. Third category of complaint, Your Lordship. Under the Whistleblowers Act. Whether under the Whistleblowers Act, complaint from department is necessary. Section 35. Section 35 of the Act, of the PC Act. So,
okay, let us assume that there is a complaint from the Whistleblower Act. That if against the complaint raised by the whistleblower, the Lokayukta has no jurisdiction, no power to investigate as per the law.
No, I'm taking Your Lordship to the rule. Section 35 of the Nagaland Lokayukta Act.
Okay.
It says that Section 35 of the Nagaland Lokayukta Act. May I take Your Lordship? Just read for Your Lordship's satisfaction. The provision of Anti-Corruption, Grievance, Redressal and Mutual Protection Act 2011 shall apply mutatis mutandi to the state of Nagaland.
Okay.
Now, may I take Your Lordship to the Whistleblowers Act? My Lord has got it?
Yes.
Now, object and reason. An act to establish a mechanism to receive complaints relating to disclosure on any allegation of corruption or willful misuse of power or willful misuse of discretion against any public servant and to inquire or cause an inquiry. This is not only for the protection of the whistleblowers, the person who has blown the whistle. Under this act, it says to inquire or cause an inquiry into such disclosure. Approval, complaint from the government department is not necessary, Your Lordship. And to provide adequate safeguard against victimization of person making such complaint and matter connected therewith and incidental therewith. Okay. Now, may I take Your Lordship to section 3? Section 3, D, Your Lordship. 3 defines disclosure. C defines complainant. Lordship. D, Your Lordship has got it.
You read C. What is C?
C is
3C.
complainant.
You read the provision. Let me also know.
Complainant means any person who makes a complaint relating to disclosure under this act.
C, complain.
D.
Yes, wait, I have not found that.
That is what I was asking, whether Your Lordship has got it.
Any person. C, any person who holds an office.
No, Your Lordship.
3.
Section 3.
Definition, you are reading definition?
D, Lordship. 3D.
3 is definitions.
Lordship. And which
What is this?
page is 4.
Whistleblower Act. Whistleblower Act. And this is for?
Page 5. Oh, is it a different copy? Section 3. See, page 5 at the bottom. Is the pagination at the bottom, Your Lordship?
Yes.
Page 5. Then complaint. C. Lordship has got it. Complaint means any person who made a complaint relating to disclosure under this act. D. I am on this. Disclosure means a complaint relating to an attempt to commit commission. This will be under PC Act. Second, willful misuse of power or misuse of discretion by virtue of its demonstrable loss discourse to the government, or demonstrable wrongful gain accrues to the public servant or to any third party, Your Lordship. Now, in this case, Your Lordship, now, if the petitioner by overstaying has accrued wrongful gain, demonstrable wrongful gain, Your Lordship, that matter can be...
I think, Mr. TB, you are stretching your case too far.
No, and may not be petitioner, Your Lordship, may not be petitioner, because it has been recommended that the petitioner should go on voluntary retirement, whatever. If the competent authority, after investigation...
See, that is the lookout of the government, lookout of the department.
No, if the competent authority has abused his power...
If some person with some ulterior motive makes a complaint to the...
Yes.
To the Lokayukta.
So
Lokayukta should not take cognizance of such complaint.
No, Lokayukta can recommend to take appropriate action. Otherwise, Your Lordship...
But you are not competent. You don't have the jurisdiction as per the Act.
How, Your Lordship?
Yes, as per the provisions. It has been read out.
Under what provision, Your Lordship? Because 9.2 is not applicable.
You are not supposed to conduct investigation or inquiry relating to matters on superannuation, service matters.
No, if it involves grievance, Your Lordship, that is why I'm saying that there's a distinction between complaint involving grievance. Grievance means personal grievance. Supposing I have applied for a job, I was not given.
Yes.
I put a complaint. No, because that is personal grievance, personal injury. For that, Lokayukta cannot investigate. There's a forum for you. But if it involves allegation, and D is a case, Your Lordship, under 9.1 read with second schedule D, in my respectful submission, Your Lordship, subject to Your Lordship's satisfaction, this is not a case of complaint involving grievance. This is a case of complaint involving allegations, Your Lordship. That is my place. And the Learned Senior Council has also relied on Section 8, Your Lordship, that approval of government. Section 8, he has relied on Section 8, Your Lordship.
Now, Mr. TB,
Lordship.
just clarify one thing.
My Lord.
If the government is saying that the petitioners will be retiring on 31st May 2024 and has issued the order, what more is left?
If the competent authority is making the petitioner to continue beyond the age of retirement or vesting, then in fact the government can look into the matter. Lokayukta can recommend against. It may not be against the petitioner. Petitioner is saying that they are willing to go, but who has stopped them? As per the recommendation, someone should have allowed them to go.
And the order issued by the government is just 2023.
Yes. So in the event, now, Your Lordship, this is only a preliminary inquiry. Now, after investigation, if it is found that they have been allowed to continue beyond the age of superannuation, Your Lordship, definitely the officer responsible against him, that action can be taken.
Okay, continue.
Now, Your Lordship, now the main issue is on jurisdiction, Your Lordship. Whether this Lokayukta has jurisdiction or not to investigate. Now, it is a different matter that release order has been issued. But this is not relevant so far as the jurisdiction of Lokayukta is concerned, Your Lordship. And here, Your Lordship, the root of the matter goes to the jurisdiction, Your Lordship. Now, if Your Lordship says that yes, under the Act, Lokayukta has jurisdiction, but this is a case where release order has been already issued to the petitioner, so no more survives. That is different. That is different. But the issue of jurisdiction has to be decided.
That is what we are on.
Yes.
That is what we are on, jurisdiction.
So on jurisdiction,
yes,
the petitioner has relied on Section 9(1), read with second schedule D, Your Lordship. But in my respectful submission, that does not, it is not applicable in the present case because Section 9 deals with complaint involving grievance, Your Lordship, not allegation, Section 9 is very clear. And complaint involving allegations and complaint involving grievance, they are totally different. So the present case is not barred for a Lokayukta to investigate. Now the petitioner has also taken, Your Lordship, the Section 8, the approval of the government. Subject to provision of this Act, the Lokayukta may investigate any action which is taken by or with the general or specific approval. Now, case of the petitioner is that approval of the government is not taken. Now, if my Lord may kindly read Section 8(1). Subject to the provision of this Act, 8(1), subject to the provision of this Act, the Lokayukta may investigate. It is not that Lokayukta shall investigate, may investigate any action which is taken by or with approval of the state, whatever. This is not exhaustive. If it is so, Your Lordship, the Whistleblower Act 2011 will not be applicable at all. It will make Section 35 of the Act, Lokayukta, redundant. Because under the Whistleblowers Act, Your Lordship, approval of government or competent authority is not necessary.
What actually cognizance can be taken as per the Whistleblowers Act?
Lordship?
What cognizance can be taken?
Under the Whistleblowers Act?
In which case? What cognizance can be taken?
Any disclosure. I've taken Your Lordship to that definition.
Kindly read that.
Now, supposing any on any allegation of corruption under the PC Act. That is one. Second, on any allegation of corruption or misuse of abuse of power by a public servant, thereby causing demonstrable loss to the government, or wrongful gain to the public servant or third party, or any third party. Now, these
Then why not actually institute an inquiry against the government who has issued the order?
No, this is only a preliminary inquiry, Your Lordship.
No.
Now, after preliminary inquiry, if it is found that the government, the competent authority is responsible for allowing them to continue.
Continue. Let us continue tomorrow.
Tomorrow witness, or Thursday, Your Lord, witness day. Tomorrow DB, Your Lordship. Or after DB or Thursday.
Okay, Thursday, I don't know.
As per Your Lordship's convenience.
Yes, Mr. City, Thursday. Thursday, I'm not very interested, but if you are interested.
Or tomorrow, no problem, Your Lordship.
Tomorrow after I think DB matters very uncertain. Sometimes we may have hearing, sometimes we have early rising. So I think let us not take
I have no difficulty, but I leave it to your lordship.
Actually, Your Lordship, I am not concerned about to be fair, I am not concerned about the issue, but I want to at least clarify regarding the jurisdiction of the
that is what.
institution.
This court will be primarily dealing on jurisdictions.
Yes.
So that will resolve everything.
Giving a view of the submissions made by my learned friend, the question which lordship is putting now, what prevented the Lokayukta to investigate and call the officers who has committed the illegality, if at all there is any? They have jurisdiction. We are also not saying that you do not have the jurisdiction. You have the jurisdiction to investigate on various issues. But in the present case, what illegal action, what corruption has been committed by the petitioners so as to investigate?
No, it will come out after the preliminary investigation, Your Lordship.
When you do not have the power to investigate on a service matter.
See, Mr. TB, assuming you are right,
Yeah,
will the right not come out by actually conducting a preliminary investigation against the officer concerned?
Starting from the officer concerned.
See?
Yes.
You are trying to leave the head, and then actually you are trying to scratch the stomach.
They have been allowed to continue beyond the age of
That is why all these things, all these things, that is why who has allowed? No. Without actually inquiring, without making an inquiry against the officer concerned, I think the approach made by the Lokayukta, even assuming we have power, I think it's wrong. That is what I feel. Of course, tentatively only. Of course, we'll continue hearing. We'll continue hearing Thursday. See, when I say Thursday, then KB is looking at me. Because Thursday, Friday, we used to sit all day for judgment drafting. At least.
As per Your Lordship's convenience.
We'll listen on Monday as the first item. We'll give you that privilege.
As per.
Okay. Mr. C.T. Jamia, Learned Senior Counsel, assisted by
I. M.
Chin, the Learned Counsel, and Mr. T.B. Jamia for Learned Counsel, for the Learned Standing Counsel, Mr. Learned Counsel for the respondent number 1, and Mr. Mr. Tiba, E. Tibapo, for the respondent number 2. You are a culprit, you are sitting quietly, eh? For the respondent number 2. The hearing remains inconclusive, listed as a parted item on 18/9/2023 as the first hearing item.
Lordship.
We'll continue on Wednesday, okay?
Monday.
Mr. Tiba, I think you just because actually you have been made as a pro forma respondent, I think you have to answer some very soul searching questions. Have you filed your affidavit also? Yes. Okay, very good. Okay. Okay, thank you so much.